Sub. What up? Good evening, everybody. Welcome to another glorious Sunday night in this our country. And if you're watching from abroad, welcome to the Freak Show. I have seen one battle after another. Slight digression, Witchbones. I happened to catch some of Rob Noor's stream where he mentions, one battle after another. They're trying to kill us all. They're trying to glorify Antifa. And if you watch that movie, I think that you can agree it's not a glorification of Antifa. In fact, there are a lot of aspects to the leftist culture there that are being mocked and ridiculed, including this need to speak in these precise codes, the focus on doctrine sometimes, a lack of follow through. And so I just find it very funny that people are using that Paul Thomas Anderson movie, where I think he probably has a kind of romantic vision of some of these leftist revolutionary movements, but to pretend that the movie One Battle After Another is just like a wholesale endorsement of Antifa and is encouraging people to go just hurt others, I think is a bit unhinged in and of itself. But hope you guys are doing well. Hope everyone had a wonderful weekend so far. We have some housekeeping to get out of the way initially. I think I have to announce this now, because if I don't, regardless of circumstances, okay, I think I can. Live update, I think I can. Okay, cool. So we are going to tomorrow. I am not going to do Lib and Learn. We might move it, unclear. But pending Drew Pavlu's non-flakiness, we will be doing an in-person discussion with Drew Pavlu in New York City. Okay? So that's the announcement. We may or may not, probably will, have a guest with us. Why this guest is coming? Fuck if I know. But because of the late nature of some of the comms, it's going to happen in my apartment. And I'm going to need to scramble to adjust to make it viable and technologically feasible. But it was we just basically, as I'm sitting here, confirmed the time for tomorrow. And so I don't really have the ability to hire a studio or anything like that. So we're going to have to make do. So that is probably going to happen now. Drew Pavlu tomorrow. Given who the guest is, I'm not going to announce it just yet. It was a kind of a oddball choice, to be honest, from my perspective. I don't really know. I'm not going to announce it just yet, but when they give me the okay that the guest is all right to announce, you'll understand maybe why. But I think we're going to have another guest with us. But given the guest, I'm not sure what we're going to spend most of our time talking about, which is a little annoying. This entire saga of, I'm just going to be honest, scheduling this conversation has been a nightmare. That said, we have a lot of fun with Drew Pavlu, don't we? 6:30 p.m. tomorrow. 6:30. Guest is Pearl Davis. Yeah. So just stay tuned for that. Any additional details. And I want to put a big caveat, which is if it doesn't happen, don't blame me. Okay? Because I am working to try to make it happen. But I do think it will. I'm going to put it at 70%. And it will be happening in my apartment. Obama secret guest, Drew Pavlu. Destroy him with facts and logic until he needs therapy. I think I'm going to need to use a different lens. Probably. And I'm probably also going to have to arrange things. I'm going to have to go out and buy a couple additional mics. So that'll be fun to just scramble to do that. But yeah. And these people will be in my space or whatever, but that's just the way the world works sometimes. That's the way the news goes. What's that from? It's from a thing. Other housekeeping. Oh, I did a spot with Crystal and Kyle. And they posted a clip of it on their channel, but I would ask that you wait to see my version tomorrow, which will be the full version. So tomorrow we'll release the full version of that conversation. It's a freewheeling conversation. I'm still a little sick in it. And so if I look a little bit like sick, I did my best to I still think it's a great conversation. I don't think that like I'm not like sneezing and stuff in it or anything like that. But just keep that in mind as well if like I sound a little bit weird or something. Is that I'm like trying various times, maybe you can tell like I'm trying not to cough. But in general, I think it's a fantastic conversation and it's worth watching. I think it'll be a lot of fun. So I recommend tomorrow we'll put it up at like 9 a.m. Rekieta law regarded or just a different perspective. I'm not sure. I heard someone tweeted at me that he was like coping about me and like seething at me after our encounter on the Laid Back Law channel the other day. And I don't know why. Because like I have certainly not focused any of my attention on going after, if it's true, right? I'm not saying that it is. I didn't watch, it's like a members only stream, so I didn't get a chance to watch it. What Rekieta said about me or whether he was seething or not. That's just how some people are characterizing it. But if it's that, like if that's true, I don't really understand why. Like I'm not going out of my way to attack his personal life, like the charges or whatever. I was very friendly when he came on. So I don't know why he would be seething or like upset if that's the case. But it might not be the case. I also saw that Kurt left barely like, I don't know, 10, 15 minutes into the conversation. That's uncivil law. And I don't know what I said that caused him to leave either or offended him, or maybe it was because maybe Rekieta was going to join and they're on the outs. So like, you have to explain it for me. I obviously am like a very passionate person about my perspectives on like different issues and shit, but like, why am I offending these people? Like, what have I said that is so beyond the pale that they can't even like stay on the stream if that's why, as opposed to the Rekieta stuff? And if it's true that Rekieta's like pissed or something, and you could tell he was like animated and shit during the conversation in a way that seemed disproportionate. I was going out of my way, and even I've gotten some criticism in my own comments, like, "Oh, you're so polite to them." I felt that I was like going out of my way to try to be patient and like adhere to the moderator and all that shit. So yeah, not sure. I think that there's also like sometimes I'm just gonna say it. A bit of a reluctance to have people outside of the hug box come into the hug box and say something that's like contrary to a core dogma. And I think that this is starting to take the tenor of that national conversation, similar to Rittenhouse, similar to George Floyd. Now we can have different outcomes in terms of how we view those cases. I'm not saying that each case is just as clear, but I just mean that it's polarizing and defining in a way that some of those incidents and cases were. Yeah, so like I didn't know why Kurt stormed off. I didn't know if he had something else to do. I saw him in the chat. Actually, you know what? Before we do this insurrection, I think this is gonna be a fun little teaching about insurrection stuff, Insurrection Act. And I think it's gonna be worth your time. But I just do want to make sure that I'm not because he did type in their chat, and I want to make sure that because if it's because of me, then like that's so we're gonna do a little fact check real quick, just a little fact check, make sure I'm not talking out of turn. I think it was when I said something like, I'm not sure if he was hit. And we'll turn on the live chat replay as well. And I think if I just Google or if I do a transcript search, I'll be able to get there. So Control F hit. I think the live chat replay. And then if I press play, you all should be able to see it. I just do this.
Ultimately get hit from that left front corner. And then he walked around the entire circumference of the car and wound up kind of back where he was when the car accelerated towards him. So I don't think he was, I think he was probably, although it's, there's no time, but it seems like he was intending on continuing his path, to complete and keep walking forward. I don't think he was trying to stand anywhere.
Oh, here we go.
3 shots and literally it's like 1.45 seconds. I'll play it again.
Yep.
So you're saying in 3 seconds, essentially, less than 3 seconds, less than 2 seconds. I'll play it again. So now timer starts and we'll see. One. So the shot. So we're talking about less than 2 seconds.
Under 1 second, he was hit by the vehicle.
Yeah. So because she
I contend that he was ever hit by the vehicle. I don't think that's been established.
Yes,
Just heads up.
That's a later argument.
So he gets up after I say that, and let's see where I'm in the chat.
Thank you for teasing that one, Pete.
So I say I don't think that he was ever hit by the vehicle. I don't think that's. I don't have a. I should have. I was actually wrong. I should have said I don't have. I'm not. I think I corrected myself afterwards. I'm not saying he wasn't. I'm just saying I don't think it's been established. That's what I should have said. I think I do correct it afterwards, but just established.
Yes,
Just heads up.
That's a later.
Okay, what does he say there?
Yeah. So because she
I contend that he was ever hit by the vehicle. I don't think that's been established.
Yes,
Just heads up. I see.
That's a later argument. But good. Thank you for teasing that one, Pisco.
Yeah, sure.
So wait. So let's say she's not hit by the vehicle, but in this.
Yeah, no doubt.
Car was in reverse.
And now I'm looking at the chat.
Let me pull it back here.
Look at this. I'm stepping out. I have no further interest in this discussion.
Let me ask Ryan.
Yeah, I mean, like I said at the beginning of this, this clip morally disquieted me.
So because I said I don't think it's been established that it's been hit, he says I have no further interest in this discussion.
Bothered me when I watched it. That my opinion on that hasn't changed. If I had to guess, what's the probability that you could get a conviction?
So he walks out where he's with Nate the lawyer, goes on his phone to say I have no interest in this discussion. I'm stepping out because I gave my opinion
against this officer in court. I'd say sub 5%. This happened very, very fast. He was rotating around the car, as we talked about. The car suddenly backs up, accelerates. I do think the point Tim Pool made about the noise and if the engine's revving and what the officer knows and doesn't could reasonably know or not know in that 2 second window. And then I think there's probably.
And look at his comment. Pisco's pissed. Like I'm the one who's emotionally dysregulated right now.
In hindsight, 2020,
as opposed to the guy who just stormed off.
A lot of stuff we could say that would have been
without exiting.
A better choice to have.
Everybody, move away from the camera right now.
Or explaining.
1, 2, 3.
Wait, everyone do what? I didn't hear you. I didn't hear you.
Move out of the way.
No.
And that's
just his perception of a possibility of flight where there's no. Oh, he admits it. I rage quit. Kurt rage quit. No encounter with a human being where to upon us. I think that's laughing in front of.
Yeah, it was not for you to actually. I know you know this, and to
of the incident his might. Remember, the gun is second is
that
not
fifth circuit. Connor saying is that you're.
I don't know if he types again.
The nature 2 seconds after that already, but it all towards you. That doesn't
about this in if. By the way, force whether the force it's not just move reasonable. If you
bumped into another car and stopped,
I mean, this is so. Okay, now that I've seen it, I'll give my comment. I have no problem talking to Kerr with uncivil law, but it just is. I think. Thank you so much, Vesraka. Yeah, I'm not gonna go out and say I know that he wasn't hit. I think it's likely he was not hit. I just don't think it's been established. I'm not confident to say I know definitively he wasn't hit, but I just think he wasn't. And I think that certainly there's not sufficient evidence to come to that conclusion. Just mute while you're scanning. Yeah, no, I mean I've seen enough. So he's rage quitting because of my opinion. So here's my statement on that. I think it's chicken shit. I don't have any problem with interacting with uncivil law or Kurt or anything like that, but if you can't even be emotionally stable enough to have a conversation with someone who disagrees with you, why did you agree to do this in the first place? Just so you could throw a tantrum? Did you expect me to come on here and just agree with all of you and just agree with your take while you're pouting in the corner? And so he tries to come up with some reason to leave and make a big show, but it's very emotional coded, very lame, So I don't know why we can't just have a civil conversation And kudos to Eric and Nate. I thought that they were, at a bare minimum, they were willing to engage on that stuff, and I thought they were like nice, super super nice. Ricada was a little bit like, but in general, at least he was there and participating. But to do that kind of shit, just like, and then talk shit in the comments, just like, by the way, he did when on Destiny's stream we had a disagreement on Trump versus United States, and I was like, this opinion is un-American or something, like it's unpatriotic or something like that. And then he rage quit that and was like, I'm not going to engage on Destiny's channel while Pisco's in there, while shit talking Destiny in the comments and saying, teaching Destiny the law would be like teaching a cat how to think or something. It was something like that. This cry bully shit where he gets butthurt at these like offenses towards him when they're not even directed and attempted to like make fun of him. Yeah, his name is Uncivil Law. And so now, like, what? Like, now I'm the jackass because I made Kurt leave or he rage quit because I said I don't think it's been established that he's been hit. And guess what? Like, I'm sorry. That's where I think the evidence is pointing. That he initiated contact with the car and the car moved. That doesn't mean that the car hit him, And even if it did, it's not like super relevant to anyone's analysis too, right? Like everyone kind of agrees, at least on this panel, that the hit or not hit isn't like the big question. And so even if like we have a disagreement on that, if we can all agree that it doesn't control the outcome of the case, I'm not sure why it should be a basis for us to like lose our shit. He was short with you from the beginning saying shit like, can we just move on? Yeah, I don't know what's up with these people. Like, I certainly get animated a lot too, but you can't do that and take it super, super duper personally. Especially when it's not like directed to, it's not like I'm lying about him, I'm attacking his family or anything. I don't know. But shout out Nate the lawyer, shout out Laid Back Law. I think that's chill. And I don't have a problem. Like, for me, it's water off of a duck's back. I am as the duck. And so I'm happy to talk and, let bygones be bygones with Kurt. No ill feelings whatsoever. I think it's lame. I'm not going to like push him on it if we ever talk again. It almost feels like he's trying to like ice me out of having conversations with people, the conservative goobers. It's like, it's me or him or something, That's kind of, I'm not sure that that's what he's doing, but I kind of feel that that there's a little of that. Like, I'm going to take the ball and like go home, which, fair play. If you don't want to interact with me, like there's no law that says you have to, but they invited me. I'm happy to do it. I think it's fun. I think it's good views. They got good views on their live stream. I think we're all better for it. And if you don't want to engage with it, but like, it just does seem like to agree to it and then like part way through before there's like any heated or passionate, like the first 15 minutes are just us like doing throat clearers and agreeing on stuff. And this is like the first point of like potential factual disagreement. And you just leave. Like, why did you agree to this? I don't know. You see Ricada streamed about your convo after the show. He's hung up on you can't have opinions because the officer is innocent until proven guilty. Yeah, like I didn't watch it because I'm not like a member. Maybe I'll get a membership just so I can watch it or something at some point. I'll do so privately. So I don't know if he's like the kind to do copyright stuff. So I'll just watch it privately or whatever. That said, like, I find this very silly. The whole like burden part of it. Like, yeah, the burden of proof is important in the context of like a criminal trial. But in our conversations, we don't have to have the same like rules of evidence and rules of like the burdens, unless we're doing some kind of diagnosis on what we think the outcome will be. But that's not what we're engaged in. We're engaged in some kind of like legal analysis in the context of like a conversation without applying like the rules of evidence, right? And it's not like anytime someone says like objection, speculation, objection, lack of foundation. That seems very intuitive to people. Like if I were to bring up how ridiculous it would be for in the context of like a online public conversation about legal concepts and shit, it's intuitive to people that bringing up the rules of evidence and objecting to it because, well, you're not allowed to do that right now. You're not allowed to do this because this is argument, you know? You haven't properly laid the foundation. You haven't authenticated that, right? Like everyone's intuition would be like, yeah, of course. Well, they would do that in the trial. And that would have to be done, and that would be like a barrier, perhaps. And when we're talking about like a prognosis or a diagnosis or what we think is going to happen, that certainly is relevant, no doubt about that. But to apply that kind of standard to the nature of our conversation, except when someone like willingly accepts it, I just think it's like a little bit sus. I think it's a bit sus. I don't know about you guys. You tell me if you agree or not. I happen to agree with myself. So that's a little bit of a recap on the weirdness, the weird little issues from that panel. I would love it if you got, if possible, this is only if you can, and if you love me, and if you love what I do, give the video, my video, a like that we just posted today. Busy people. But we love that stuff, and I want to do more of it. I love these conversations. I'm in talks with like 3 different people. Maybe we can schedule some of those conversations this week. But one far left, one right, or sorry, 2 right wingers, one more far left person. So I don't want to announce things until they're ready, but hopefully there'll be stuff next week or this week, I guess. And I do want to check in with Connor at some point. It's not like Rekieta makes wild claims about his political opponents or anything, calling protesters rioters before there's been any. Yeah, Rekieta, like, what's up, Rekieta? Not our Pisco. Stealing them blind. And he gets to be a lawyer. I should have stopped him when I had the chance. You're slipping pisser. What a sick joke. Okay. Any other housekeeping? Let me think. I didn't really go into I didn't read like the threads. I saw Hutch responding to Hassan, responding to Soypill, but I didn't go through the threads. Maybe at some point we'll do that to give my take on it. My sense is that there's talking past each other. And my sense is that Hassan Piker, as like a lot of left-wing people, very left-wing people, and I've had this when I talk to Ogre Boy as well, don't feel comfortable in the particular criticism that is levied. And so it's like a kind of shifting dialogue. Like, why would we talk about this? Shouldn't the blame be on Biden and Kamala for this, that, and the third? Right? That's what, and the answer can be yes to that. Like there can be blame for those people, but it's not responsive. And so that will always trigger the hell out of me. Is before we actually get to common ground, and maybe there is common ground. I mean, like, think about all the things that you do in your life and regret you might have. It's the odd person that doesn't regret anything they did or a stance they took. Even look at Anna Kasparian. Look at how much we disagree with Anna Kasparian. She came out and said, listen, I think like my kind of equivocation about Trump was wrong to do. And so if the question is, should we have endorsed? That's the question. Should we have been public in endorsing or advocating for someone to be the candidate? That's the question that we need to resolve. All right. And if the answer to that is, I don't want to talk about that, then they should just state that. I came at Mamdani, even though I endorsed Mamdani early on. I want to say, like, it's kind of weird. I saw the live stream fails Reddit seems to say, like, as though Hassan's going after me. I don't think he's going after me. I think he's going after Hutch and Soypill on some of it. But if it's like, well, don't talk about whether or not I should have done something or whatever, because I don't want to talk about it. I would rather talk about something else. Then just say that. Mamdani should have endorsed Kamala Harris openly. And notwithstanding that, I endorsed him early on, I should say, and before he won the Democratic primary. But I don't have much respect for dodging the question, right? And for not interacting with it. Right? So grant that Kamala and Biden fucked over the American people on some things. I think it's more Biden's decision to run again, to be honest with you. I think a lot of this, in fact, I even think on some scores, like the blaming of the lefties doesn't have an empirical basis in it. And so I'm often like, well, I think that the lefties by and large voted for Kamala. All right. So I'm not even empirically convinced that it's the case that they cost Kamala the election. But that's not the claim, right? Grant that Biden made some mistakes. It doesn't change what people are asking for, which is, should it have been the case that Hassan, Denham's, lefties, anyone who could see, as it was apparently obvious, that Trump would be a disaster, both in absolute terms and relative to the competition? Would it be the case that it was justified to equivocate? By which I don't mean make a false equivalence, okay? So I want to be clear. When I use the term equivocate, I'm not using it to mean a false equivalence. What I mean by equivocate in this context is to use like kind of unclear language to hide an ambiguity as opposed to being crystal clear. That's the question. What was the right thing to do given the circumstances? And any amount of, she didn't deserve my vote. This is the conversation I had with Ogre Boy. Ogre Boy, who I have a lot of fun with in certain conversations, but who I think is victim to the same exact thing. Right? She didn't deserve the vote. She didn't deserve the vote. They should have done this. Yeah, maybe they should have. But this, like, what I think is incredibly opaque and frankly, I think sometimes even worse than that. I think it's intentionally vague, intentionally loose. Notions of deserving vote as opposed to should you vote for that person? And is there a difference between those notions? That to me triggers the fuck out of me. So maybe we'll review the back and forth there at some point. But needless to say, obviously, yes. Obviously, any thinking, sane person looking at the administration that we're living in retrospect, who failed to endorse or vote in clear terms as opposed to unclear terms for Kamala Harris, that was a mistake. And it should be simple to acknowledge it as such. That is not a difficult question. But if it's a question that one desires not to answer, just say so flatly. The deflection to the obligation of the DNC, the Democrats could have done this, is just that, a deflection. It doesn't resolve the underlying question at all. And I don't respect it. But yeah, that's housekeeping. Other stuff. There might be one other thing before we get into Insurrection Act stuff. No, I think that's it. All right, cool. Folks, one thing that you'll see in the discussion I had with Kyle Kulinski and Crystal Ball was, or at least the first thing that we talk about in the video, is the prospects of the invocation of the Insurrection Act. And I want to just tell you right now that it's not a question of if. It's a question of when. All right? So I don't want you all to live in this uncertainty. I'm telling you right now that they were always going to try to find a pretext to invoke this Insurrection Act. So what do we do with that knowledge, right? The first thing to do is to stop fretting on the uncertainty. Accept it. Accept that it's going to happen. And let's A, think about what that means. Let's B, inform ourselves regarding what the Insurrection Act is. And C, let's chart out our best responses to the Insurrection Act. I want to justify, though, a little bit why they want to invoke the Insurrection Act. The first is, I think, obvious. They want to use the authority of the state, by which I mean the federal government's power, to enforce compliance through fear. It's not too dissimilar to Trump's conduct in foreign affairs and international politics, where he has a more open hand. He is trying to get people to comply by taking action, which in the specific instance appears to demonstrate strength and overwhelming force. This exists in many different contexts. As I already just mentioned, in the international affairs, it exists with respect to certain agency action taken against non-compliant law firms, companies, etc. It's a kind of all or nothing prospect that you're a friend of the administration, you're willing to play ball, you're willing to make a deal, you're willing to bend the knee and to make an offering to the sovereign, in their mind, the sovereign, which is Donald Trump. Or we are going to use every tool at our disposal to force compliance and to cause anyone who is observing this back and forth in the given context to be fearful of what happens when the federal government comes to their doorstep, which I mean both metaphorically and literally. Sometimes they're arriving at people's doorsteps. This is also true of the weaponization of the Department of Justice. The weaponization of the Department of Justice, which is being used to target political enemies. And it will not just in the nature of the individual prosecution have an effect, obviously. It will have a chilling effect on individuals within and without the federal government and in state governments to preemptively comply to what is this anticipatory compliance, whatever the concept is. And the use of the military domestically is a way to accomplish that. So that's number one. Why? It fits their broader goal of establishing a republic of fear and trying to coerce compliance, both of the specific actors who are the target of the use of force / government action, and to anyone else watching. If they establish they can do this and get away with it, then in the future we won't have so many dissenters. Okay. But then why use the Insurrection Act specifically? Well, they try to use other authorities. They tried to use this section 12406. And we went through that whole affair where what was being attempted was a federalization of the National Guard to put what are usually under state authorities, the state militias, in the hands of the national government. And as you imagine, and as we spoke about, the state militias, as a default presumption, are in the hands of state governors. That there is a presumption in the Constitution, and which you can find throughout the writings of the framers, and a fear, a jealousy to guard the militias. Thanks for the sub. Think about the Second Amendment, which says, the well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. regardless of whether you conceive of the Second Amendment as an individual right or not, the primacy of the Second Amendment and the militias, which was directed at the federal government. Remember, the initial Bill of Rights only targets the federal government. It's not till later amendments and interpretations that it applies more broadly after the Civil War with the passage of the 14th Amendment. But initially, that was about the relationship between state and federal government. And of course, the militia played a prominent role in that. And the state militias don't owe their existence to the federal Constitution, just as the states themselves don't owe their existence to the federal Constitution. They're a creature of their own state constitution. They're founded from the original colonies of Great Britain. And so he tried to use one of the sources of authority that Congress, who has the power under Article 1 to give the rules for calling forth the militias into federal service, right? Commander-in-Chief is the president is the commander-in-chief of the militias when called into federal service. But Congress has the role to actually provide for calling forth the militias. Some of these early statutes were called calling forth statutes for that reason. And so one of them was this Section 12406, which the Supreme Court ruled that the main legal theory that Trump was employing was essentially impossible. They were signaling their hand on that in this most recent decision coming out of the Seventh Circuit. That one of the preconditions that was reviewable by the court didn't say unreviewable, court reviewed it, that one of the preconditions required inability with respect to the regular armed forces. And that unless you can show an exception under posse comitatus, which is the law governing whether or not it's legal, to use the military to enforce civilian law, that unless you had an exception under that provision, that you couldn't use the subsection of 12406 because you wouldn't have a precondition to even enforce the laws at all, and enforcing the laws under that subsection made reference to the regular forces, which was a term of art meant to imply the military, not like ICE or civilian law enforcement. And so point number 2 is, to fulfill their ideological goal, their previous use of authority wasn't sufficient, as found by the Supreme Court in this recent case that I'm referencing. We'll take a pause for a question. Complete layperson here. Were the National Guard under the authority of the federal government, would states no longer have a well-regulated militia of their own, warranting the creation of such forces? Right, so that's an important question that is going to inform our analysis of the Insurrection Act, which we'll talk about shortly. And I'll draw a little bit here as well. So we understand the immediate ideological desire of the administration to impose itself, to establish obedience, and to quell dissent. We understand why their previous attempt was insufficient legally. The Supreme Court made a couple of interpretive decisions which effectively defanged the main argument for calling forth the National Guard into federal service. Okay? Now, there's a potentially anomalous result that the Supreme Court decision could conceivably lead a president to do. And Kavanaugh pointed this out. But when you take a step back, it's not that anomalous. And that is that it might actually incentivize a president to use the military more readily in these civilian contexts, as opposed to the National Guard, who are typically thought of from a policy perspective of having a closer connection to their local neighborhoods, local whatever. And so that seems a little bit more burdensome. And in our just consciousness as well, most people would feel less comfortable with members of like the regular forces walking around our streets than perhaps members of the National Guard who are from that community. But it's not that anomalous from a constitutional perspective, even though from a policy perspective, you might consider it as such. And that's because the policy reason for it is unconnected to the animating principles of federalism that make it harder to commandeer state actors for federal purposes. Of course, it makes sense that the federal government would be more restricted in calling forth state assets for federal purposes, given our starting set of assumptions that the states retain their sovereignty and that they should be protected under the original conception of the Bill of Rights, which is meant to be a bulwark against federal encroachment. And so it's not that anomalous. But okay, so what is Trump to do? Well, Trump has two problems, or potentially two problems. The first is, we'll call this the National Guard problem. So he needs problems for Trump. He needs a basis if he wants to use the National Guard, which he probably does for optics reasons, etc. He needs a legal basis to do this, or at least a purported legal basis to do this. And then two, he needs an exception to posse comitatus. He doesn't just want to use these armed forces to just do nothing and to just defend military installations or defend federal buildings. He wants to actually use the military or the National Guard in national service to enforce civilian law. This, by the way, raises concerns of the midterms. Just keep that in mind. And we talk a little bit about that as well in my segment with Crystal and Kyle. And something that was actually floated by Trump during that transition period in 2020 was to invoke the Insurrection Act or to get the National Guard to seize voting machines, etc. So this is not something that's beyond his conception. It's something that he's talked about before as well. And so how do you solve these problems? You want to use a National Guard to some capacity. You also probably want to use regular forces. And you need a legal justification now that it's not available to you to do so. And you need a way around posse comitatus because you don't just want the military people to stand there. You want them to do stuff. And typically, right, doing patrols and enforcing civilian law of the state, that is going to be outside the scope of authority under troops, typical marching orders, and outside of what posse comitatus allows as a default presumption. Okay? So that's where we're at. And the Insurrection Act resolves a lot of these issues for Trump because the Insurrection Act is at once an exception to the general rule that the National Guard is under the control of the states, and it is an exception to posse comitatus in certain circumstances. And I will explain why. I will also try to tell you why I am less certain, why I am scared of the legal result here. Now, I don't want that to stand to reason that I'm generally scared and think that you should be fearful so as to blackpill you. I don't think so. I think we're going to win. There are many more of us than there are of them. And I think that with peaceful protests, with the elections coming up, and if we maintain our focus and remain not paralyzed into inaction by fear, we will be triumphant. Okay? So I just want to make that clear. When I say fearful here, I just mean about what the courts are going to decide, merely in that context. Because I think it's far from certain that Trump loses on this score. And it's not because I think he has a good reason to invoke the Insurrection Act. I don't think he has a good reason to invoke the Insurrection Act. And we'll talk about why he didn't just go straight to the Insurrection Act as well I'll say that next. But it's because of how the law is written. But before I do that, let me say why he didn't go straight to the Insurrection Act. He didn't go straight to the Insurrection Act because it's seen publicly as a drastic action in a way that, 10 USC 12406 isn't, okay? Insurrection Act. There's an insurrection. The name of it implies a drastic action. As well as the longest period, I believe, in U.S. history that the Insurrection Act has not been invoked. The last time was in the LA riots in the early 90s, before I was born, before many of you were born. And a kind of recognition in the post-Civil War era, in the post-Civil Rights era, that the relationship between state and federal government, though at times frayed, they generally cooperate when it comes to issues of public disorder, of civil disobedience. This was the case, by the way, in the LA riots, where they were actually not it wasn't like the state authorities were trying to repel the federal government. You get me? It's also a true statement of the Floyd protests and riots that it happened in the 2020 era, which is there were federal abuses during that time. No doubt about that. But by and large, Trump and the states worked together. Yes, they publicly attacked each other viciously. Trump was unhinged in his tweets. But it wasn't as though they stopped coordinating and stuff like that totally. There were a couple instances here and there, no doubt, for sure. But Trump actually, if you recall, publicly praised the response of some governors to the riots, including Tim Walz, governor of Minnesota then, governor of Minnesota now. So this would be seen as a drastic action in public from a PR perspective. And it wasn't necessary to accomplish what the Trump administration wanted to accomplish in these shows of force, try to claim, lower crime rates as a result of this action taken. They didn't need to, but now they do. And they're looking for a pretext to do it again. In the context of 10 USC 12406, they use the attack on the Whiz Kid, the Elon Big Balls kid. I use Whiz Kid, by the way, ironically. I'm not trying to say that he's super brilliant or whatever. But they're looking for some pretext. And what happened with Nick Shirley and the lies being told and the outcry from conservative media and the misframing of conservative media on the fraud that occurred in Minnesota, that has given a ripe opportunity for Trump to take advantage of some aspect of discomfort among his base with recent actions. He's trying to throw some meat to the base. I'm not trying to imply that the base has abandoned him. But these people are online and they're seeing perhaps less public approval, less glowing reviews than they would like to see. And they also want to accomplish their primary ideological objective of turning our country into something less than a republic and enforcing their edicts through fear. Which brings us to the Insurrection Act, which is a power that has been requested by the most extreme of the MAGA base to be used for years now, going back to Trump's first term. He should have used the Insurrection Act against all these George Floyd protesters, all these George Floyd rioters. This was the outcry from members, even people that we talked to, people like Rob Moore. He should have invoked the Insurrection Act. These damn lefties. Okay, that's our context. That is our context into the framing here. Why he hasn't used it so far, what using it accomplishes from Trump's perspective. Right now, there is a bit of a stand down, or I should say a standoff, between protesters, in some sense, and federal law enforcement. Trump also wants to do the mass deportations, and he probably thinks that doing this kind of action was going to increase the ability of ICE to do that. I'm not convinced of that, because I think this kind of action is going to engender much opposition, but this administration only knows one currency, and that is brute force. That's the currency they understand. And it's the only thing at times that they value and respect is brute force. So they think that in doing these actions, perhaps they'll be able to accomplish their immigration goals as well. But they should be more, if they were more wise, they should see that the numbers on immigration are rapidly declining. And we spoke about this a little bit before, that it has to do with diminishing returns on immigration action. Diminishing returns in terms of who you're allowed to go, who you're able to go after from a practical perspective. You've gone after the people who are easy to go after. Everyone else now is more aware. They're trying to evade the administration in some respects. They are more embedded in communities. They're law-abiding in a way that perhaps some of the people who are in the system, so to speak, from a criminal perspective, would be less able to evade. And then you have the personnel problem. A bunch of mistakes, a bunch of lack of training incidents has caused ICE's reputation to decline to new lows, to the point that there's a taboo against ICE now, more so than before. You see this even with people like Joe Rogan, other commentators who I think generally are stupid and weak on Trump, saying like, "Oh, we didn't know they were going to do this." Right? Imagine, right? Imagine Joe Rogan. "Oh, this ICE stuff so bad. We didn't know this was going to happen." They're literally like babies. Some of these commentators, some of these comedians, they're babies. You didn't know that they were going to do it. What? Are you like a naive baby? And also, they feel the pressure on them from the midterms. I mean, they're running out of time, folks. It's less than 10 months until the midterms. And Trump's approval ratings are not recovering. And if Democrats sweep, even take one house of Congress, the ability for Trump to make his legacy, his imprint in the way he wants to. Right? We always think he'll have a legacy here, and the next administration that's Democratic is going to be cleaning up this mess for the entirety of their term. In fact, we as a country will never be done picking up the pieces that this administration has left us. But there is a threat. They're running out of time to do the things they need to do, and the public is not liking what they're seeing. So something needs to change. Introduce anarchy, introduce chaos, right? There is a feeling that taking certain drastic action might change the narrative, change the script. So those are some of the background considerations that I think are at play here. Now on to the authorities. First thing to keep in mind is this is not a correct codification anymore. 10 USC 331 to 335. That's an old meme, okay? It's an old code and it doesn't check out anymore. Also, there appears to be a typo in this PDF. So if you see this PDF, it's from a government website, this is not correct anymore. That's the first thing to note. Another thing to note is that the Insurrection Act is not just one section. It is a collection of different sections. Okay? That's not unusual, right? The Immigration Nationality Act has many different sections, and so when you're thinking about the Insurrection Act, it's actually a set of different sections that constitute the Insurrection Act. Those are some background considerations on what the Insurrection Act actually is. You're not looking for one section, you're looking for multiple. This is the current codification, 10 U.S.C. 251, right? So not 10 U.S.C. 331, 10 U.S.C. 251. However, just for, so you can see them all in one place, I'm going to use this PDF to show you the differences and what the whole deal is with this Insurrection Act. And that's going to include reading all of it. It's not long, guys. And we can skip 335, which just defines Guam and Virgin Islands as being a state, okay? So we don't have to read 335. It's literally a page, and you guys can handle it, okay? So, the Insurrection Act, the first part of the Insurrection Act is this section, not 331, right? Section 251. But you can check it by its title, Federal Aid for State Governments. Put aside what you think you know about the Insurrection Act as just being about insurrections, definitional insurrections. It's both broader and more narrow than that in some ways, okay? It's both broader and narrow than that in some ways. The first part of the Insurrection Act applies when state governments want help. So when they ask for help. It says whenever there is an insurrection in any state against its government, right? So the denominator here is an insurrection against the state government. The president may, upon the request of its legislature, the states, or of its governor, if the legislature cannot be convened, call into federal service such of the militia of the other states in the numbers requested by that state, and use such of the armed forces as he considers necessary to suppress the insurrection. So this first part of the first section of the Insurrection Act applies when a state legislature, unless they're unable to convene, in which case it would be the state governor, requests help from the federal government. And of course, this doesn't provide for necessarily a federal service for the state militias within the requesting state. It says federal service of other states. What is the logical entailment of that, right? The logical entailment of that, or at least the suggestion, is that this statute isn't about doing something against the state's wishes. This is about helping a state that is requesting help. And so it applies to insurrections, but it doesn't apply to insurrections against the federal government. And it only gives authority to call into federal service the militia of other states for the purpose of suppressing the insurrection. And so the first thing to note about this part of the law is that it applies to state insurrections, is that it requires as a precondition the state legislature to request help. It applies to insurrections only and nothing else. And it doesn't work as an exception to posse comitatus, right? Because what you're calling the state militias of other governments to do, other state governments to do, is just to suppress the insurrection, not to enforce the law, which is, they're technically different things. It's not entailed by suppressing the insurrection that you are allowed to enforce the law. So the first thing you should note is this is not applicable, okay? It's not really going to help Trump. There's a procedural component that he's not going to be able to satisfy in the state of Minnesota, namely the consent of Minnesota by its legislature. There's a problem that all the protests are directed towards the federal government as opposed to state governments. And so to the extent of an insurrection, it's not directed at the federal government. And then it's not an exception to posse comitatus. So the kind of things that they're going to be allowed to do is limited to just suppressing whatever insurrection, if it exists, against the state. And so this is a highly tailored statute, this part of the Insurrection Act, that by and large, I think makes sense. This is the kind of statute I'd like to see. The rest of it, though, we're going to have problems. And I'm just going to preview for you that I'm concerned. I'm concerned. That's all I'm saying. All right. Next section. Use of militia and armed forces to enforce federal authority. Okay. So now we are getting into it. So this is about enforcing federal authority. Whenever the president considers that unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States, right? So we have obstructions, combinations, assemblages, or rebellion make it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceedings. He may call into federal service such of the militia of any state and use such of the armed forces as he considers necessary to enforce those laws or suppress the rebellion. We're getting closer. But I don't think we're there yet. Spoiler alert. This is the part that I'm most concerned about, 333, okay? So here, it's broader than just insurrection. In fact, it doesn't even mention insurrection. It says obstructions, combinations, or assemblages, or rebellion. So in some sense, you could say obstructions, combinations, or assemblages. None of these terms are defined in the statute, by the way. So keep that in mind. There's a bunch of interpretive questions here that hasn't been done. The work hasn't been done by Congress to define these terms for purposes of the Insurrection Act. So a lot of question marks about what obstruction, combination, or assemblage means in the context of the Insurrection Act. It's not enough to just say, well, in one context, conspiracy means this, and another context, obstruction means that. There's a specific analysis you're going to have to run if you're going to use originalism on these words in the context of this statute. So in that sense, maybe it's broader. It's affecting more things than mere insurrections. But then there's this other hook. Make it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceeding. So this law and use of 332, which is not really 332, right? Remember, this is 252, right? 252. In fact, I'm just going to make that clear. This is 251. This is 252. This is 253, right? And 252, what is the hook here? Judicial incapacity. So what you need to show is that the ordinary courts can't enforce the law or suppress, the ordinary forces, the ordinary enforcement of law cannot deal with this situation. And this is an exception to posse comitatus, right? Using the armed forces and the militia to enforce the law. So this gets into an exception of posse comitatus. It allows, as posse comitatus envisions, certain statutes can authorize enforcement by the military in some circumstances. This is a direct exception to posse comitatus. And it allows both the calling forth of the National Guard and the use of the armed forces to that end, not just to suppress the rebellion, but also to enforce the law. But there's this threshold problem, perhaps, that Trump would have to face of judicial incapacity. Are the courts in such a state that the ordinary course of judicial proceedings are unable to make it impracticable to enforce the laws of the United States, by which you mean the federal laws? No. That's not the state of the Minnesota situation, that the courts are unable to handle the massive amount of obstructions, combinations, assemblages, or rebellions. So there's at least, I think, decent argument here on judicial incapacity, that we aren't in a state where the courts are unable to do it. But it's not as clear as the first one, in my opinion. Why? Look at that first clause. Whenever the president considers. So it's a who decides issue. Who decides whether it's impracticable by the ordinary course of judicial proceedings to do X, Y, or Z? That's a threshold question. Presumably, the first section here, 251, which doesn't include whenever the president considers, and which has this specific procedural requirement, the courts would be more comfortable weighing in on this. But even if no reasonable person would say that it's impracticable to enforce the laws by the ordinary course of judicial proceedings, do reasonable people, or indeed Article 3 judges, get to second guess the president's determination? So I expect in any litigation over the Insurrection Act for the government, Trump's government, not to concede 252. Even though we, in the ordinary course of judicial proceedings, think that it's practicable to enforce the laws of the United States, there's a threshold question of who decides and determines that this is the state of affairs such that the use of the military and the militia is justified to enforce the laws. Has Congress, by enacting this statute, kicked the courts out of the equation and given everything in the hands of the president? I think that the proper answer to this is no. I would impose on Congress a clear statement rule that if you want to deprive the courts of judicial review, that you should say so clearly. There is case law from the 1800s, this case Mott, which some courts have seen as supporting the proposition that the president, his determinations should be given conclusive weight. I think you have probably 4 justices who would agree with that proposition, including Kavanaugh. How he wrote in the decision on the National Guard seemed to suggest strongly that if you just write the memo a given way, Kavanaugh is going to play ball and is going to agree with you. All right? That is a narrow margin, in my opinion. At least 4, maybe more. And you only need 5. So even though I would read these statutes as requiring some sort of clear statement before we're going to kick the courts out of their review function, it's not clear the Supreme Court would agree with me. Martin v. Mott is the case. That's right. Martin v. Mott. But there are other cases after Martin v. Mott, that I think read Martin v. Mott properly, which is not to say that all of this is unquestionable from a court perspective, but namely that an individual soldier can't reasonably be said to second guess the president. And then recent case law regarding the Alien Enemies Act, which does suggest that these kinds of issues are determinable by courts, some of these preconditions. So I don't expect the Trump administration to forego or concede judicial capacity. I think that they will say that there is incapacity, and they'll at least make some sort of conclusory finding as such. And the question is, will the courts give deference? And my inclination is that you have at least 4 judges who will on the Supreme Court, just on the mere statement of the president. But if I were to decide this issue from a legal perspective, my position would be that there is no judicial incapacity in Minnesota such that it's necessary to use the armed forces and the militia to enforce the laws. And I think that the courts are at least competent enough to resolve the question of judicial capacity. If the courts are unable to resolve the question of their own capacity, I think we're in trouble, folks. Think about that. Think about that conclusion, that a court would be unfit to assess that issue about whether their own branch of government has the capability to enforce the laws. I do expect him to invoke 252. Well, I expect him to just make reference to like the entire thing, 251 to 255, right? He's going to cite the whole Insurrection Act sections, all right? But in court, I don't expect him to vigorously argue for 251. I expect him to vigorously argue from a structural perspective that the courts aren't allowed to second guess his determination as to 252. And then on 253, I think he's going to go wild, and I'll tell you why. Okay? So that's 251, that's 252. I've referenced some of the judicial review issues that might come. This is a structural fight. This is a who decides question. Who decides the preconditions? Can the courts have any amount of review? Do they have to give deference? Do they review just for good or bad faith? Or do they review for something with more teeth? Okay? But now we have, unfortunately, the most vague part of the Insurrection Act. And if you had to ask my opinion, I think that the likelihood is that the court will not meaningfully restrict this language in a way that I think would be in keeping with the spirit of our Constitution. And I think Congress should amend this as quickly as possible for a reason that I'll get into. But Section 253 has two parts to it, with one initial clause. The president, by using the militia, right? It's called interference with state and federal law, or the armed forces, or both, right? Or by any other means, shall take such measures as he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combination, or conspiracy. So this is at its broadest. So not just insurrection, domestic violence, unlawful combination, or conspiracy. What does that mean? So a lot of ambiguities there. Not so much on insurrection. I think insurrection has a pretty fixed meaning here. But in this context, what these things mean, right? And then once again, it has this phrase, the president shall take such measures as he considers necessary. So the same question of who resolves the preconditions, who gets to review them. Is it just the president? But now even broader language, right? Not just unlawful obstructions, combinations, assemblages, or rebellion, but insurrection, domestic violence, unlawful combination, or conspiracy. The typical usage of conspiracy only involves two people. And not even public, right? I could conspire with someone to commit tax fraud. You get me? Hypothetically, you could conspire with someone to, give a false statement to the FBI. Conspiracy, in its ordinary usage from a criminal perspective, is incredibly broad to cover all sorts of different agreements. Okay, that is to say, if any of these, thank you so much. Did you see Governor Newsom's Ben Shapiro podcast? Can you, for my purposes, describe what sort of ruthlessness you'd like to see from the Democratic president and what ruthlessness you would oppose? Maybe I'll watch that after this, actually, if there's no call-ins. I'll defer to call-ins if there are call-ins, but I want to watch it. I haven't seen it. I've heard different things, and I will give you my honest take in real time. From that, okay? So quite broad categories here: insurrection, domestic violence, unlawful combinations, or even just conspiracy. So this is going to limit it some. One, so these are the two parts. One, so hinders the execution of the laws of that state. So now you're able to make reference to the laws of the state, not just of the United States. It's both, right? Of that state and of the United States within that state. That any part or class of its people is deprived of a right, privilege, immunity, or protection in the Constitution secured by law, and the constituted authorities of the state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection. Woof, right? Woof. Now I'm more at ease, right? For sub 1. All right. This isn't just talking about any conspiracy or any domestic violence or any unlawful combination. We're talking about such things in the context of it hindering the execution of the laws of the state or the United States, that some class of people, any part of its people or class of its people, is deprived of constitutional rights. And also, right, and that the state is unable, failing, or refusing to protect that right, privilege, or immunity from the Constitution, right? So that is a limitation. All right. So once again, the same ambient concerns about who decides, the same concerns about whether or not the courts are able to rule on this, those are present, but we have this like real limitation in sub 1 of 253. And of course, in any situation covered by the clause 1, the state shall be considered to have denied the equal protection of the law secured by the Constitution. So in sub 1, if that happens, we consider the state to have denied equal protection of the law secured by the Constitution. Now, query whether or not a statute is able to make out those kinds of violations, but fine. All right, that applies to 1. There's some real preconditions that need to be met under the Insurrection Act here. So presuming that the courts have some role in oversight regarding the president's determinations, maybe put this in the same bucket as the first 2, in that there's some real teeth here. The problem is sub 2. Opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. What the fuck does that mean? Right? Remember, this is or. So let's read it at its most broad interpretation. The president, by using the militia or the armed forces or both, or by any other means, shall take such measures as he considers necessary to suppress any conspiracy if it opposes or obstructs the laws, execution of laws of the United States, or impedes the course of justice under those laws. If you take it at its maximalist reading, this would eviscerate posse comitatus completely. Because all you would need to show, right, is that the president determines that the military is necessary to enforce the laws, or to suppress a conspiracy that opposes or obstructs the execution of the law of the United States. Well, that seems to be almost definitional. If you're engaged in a conspiracy to violate the laws of the United States, it almost seems like preordained that you're opposing or obstructing the execution of those laws. Maybe not. Maybe you need to show some sort of opposition to the actual enforcement itself as opposed to just mere violation of it. But read in its most broad sense, this seems incredibly dangerously vague and broad. And I don't know how the court is going to read it. This is why I'm concerned from a legal perspective. Because I think that the argument on 253 sub 2 is very shaky and uncertain. Should we read this in light of the animating spirit of the Insurrection Act and the Civil War? That is, this is really about situations in which there's a concerted effort to prevent government itself from functioning. Almost misspoke there. This is about a concerted effort to prevent the execution, not just law breaking, but law breaking such that you're trying to get rid of or oppose the government's ability to enforce the laws. So putting aside the issue of who gets to make the determinations as to the preconditions of the Insurrection Act, the strong possibility that the court would give huge amounts of deference to the president. There's an also strong possibility that the court would construe sub 2 broadly. This vague and ill thought out provision, which, if read to that extent, makes a mockery of our, in my opinion, our rule of law and posse comitatus itself. Some cleanup considerations. Cleanup consideration number 1. Maybe a background argument could be that if the proper statutory interpretation is the broadest reading that I've provided, that perhaps it would so eviscerate a state militia and their right to exist that it would itself be unconstitutional. Here's why I think that's probably not going to work. I doubt that the court is going to be interested in a test that meaningfully limits Congress's authority. And the court here in interpreting Congress would have the last say in our context, determine what Congress wanted. And so to the extent that there's this federalism concern, this was passed after states rebelled. This was passed in light of the 14th Amendment. The precursor is actually before it, right? There are precursor insurrection acts before the 14th Amendment. But, the more modern incarnations of this were passed after states attacked the federal government. So why should we give deference to the states and their militias in light of that history over Congress, who we've interpreted to have this particular desire in our interpretation of the statute? Yeah, you can. I'm gonna do Collins Ice Beans in about probably 5-10 minutes, so you can definitely hop in if you want, and we'll defer to Collins before we do any kind of Gavin Newsom analysis, if such is requested. That's a kind of additional argument maybe some state can raise, or some petitioner, that the law, if interpreted as broad as it might be understood, that it would be some sort of unlawful intrusion into a state's ability to manage its militias. That's the Insurrection Act. My overall thoughts are that we are in uncharted territory. Trump is going to try this. We are heading for a standoff, and I want people to be prepared for it. And I want people not to be scared. Because if you just give in to your fear, then they win. And we are all loyal patriots. We're all lovers of our country here. And so regardless of what the Supreme Court may say regarding the Insurrection Act invocation, which I think is forthcoming, how we respond should be largely the same, which is continue to peacefully demonstrate, continue to vigorously oppose this government, and to not be quelled by any would-be tyrant, by anybody who is claiming emergency authority, and to protect one another peacefully and patriotically. So if this legal fight goes the wrong way, which it's entirely possible, I want you to remember that. We're not going to abandon our country for the whims of Trump. regardless of what the Supreme Court says. And one of the first items of our agenda, when we win, will be amending this law to make it more clear and limited. We have a lot of amending to do. Frankly, I think one of the big negatives about the previous administration, Biden's administration, is the failure to amend this to be more clear. They amended the Electoral Count Act. Probably should have included the Insurrection Act there too. Talk about 254. There's at least a procedural limit there. It's not much, right, though? Whenever the president considers it necessary to use the militia or armed forces under this chapter, he shall, by proclamation, immediately order the insurgents of those or those obstructing the enforcement of laws to disperse and retire peacefully to their abodes within a limited time. Like, yeah, he's going to do that, but he'll just do that in a memo and then immediately walk in. And they're like, well, what does limited time mean? And yeah, I already did that. And we went in like a minute after. And so is the court going to come and say, well, you didn't give him enough time? I just think that these kinds of procedural requirements don't give much hope for me for the legal case. I think it's something. But yeah. Okay. One thing also to note here, and I think Breyer, I've been very praising of Breyer, Judge Breyer out of the Northern District of California, but I think his omission of sub 2 is a bit suspect. Look at his analysis when discussing possible exceptions to posse comitatus in this case out of California. He's determining whether there's an exception to posse comitatus, and he sort of speculates as to whether the Insurrection Act would provide that justification for Trump. Is what he says. Nor does the Insurrection Act 251 to 255. See, it was until recently codified at 331. All right, so you should believe Pisco. Support defendant's position here. To be sure, the Insurrection Act is a recognized exception to the Posse Comitatus Act, as I mentioned. Yet the Insurrection Act, which provides 3 avenues, really 4, right? The third avenue has like a and B, like a sub 1, sub 2. For the president to deploy the National Guard or other branches of the military imposes meaningful guardrails on the president's authority. And look how Breyer interprets it. Again, I'm with him initially. The president can invoke the Insurrection Act only if, 1, the state legislature or governor so requests it. Agreed. He determines that unlawful obstructions, combinations, or assemblages make it impracticable to enforce the laws by the ordinary course of judicial proceedings. Agreed. That's a meaningful restriction. Absolutely. Or 3, he determines that any insurrection, domestic violence, unlawful combination, or conspiracy so hinders the execution of laws of that state and of the United States within the state that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution as secured by law, and that the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give the protection to the state's citizens. Well, Breyer, and well, first of all, before I go at him, under the Insurrection Act, then, the president's authority is restricted in some way, either by a request by a state legislature or governor, by findings of the courts, or by the inability or unwillingness of local officials to act. What's the problem with what Breyer is saying here, though? What's the problem with what Breyer is saying here? Can you link the document? Just Google the following, all right? I'll tell you what to Google. Google Breyer Posse Comitatus PDF. And it should be the first thing, all right? Breyer Posse Comitatus PDF. We'll get there. What's the problem with what Breyer is saying here? Everything's correct. Does anyone see it? What is Breyer getting or hiding? In my opinion. Nope, not incapacity. I'll tell you. Sub 2, right? Yeah. He got 1 right. But what about sub 2? Where's sub 2? It's completely missing. And I think that that's telling. Right? You have 253, you quote it from 1, but then you ignore or 2. And I agree 1 has a meaningful constraint. I don't know about 2. Now, I would read 2. I want to be clear about how I would read 2. I would read 2 as being limited in some sense to the kinds of situations that the Insurrection Act was meant to encompass. I would limit it to some amount of state incapacity or complicity. But the words are vague and broad. And Breyer doesn't include them. And I think it's telling. I think it's because Breyer recognizes, as many people who love freedom recognize, that the same constraints that are present in the other provisions of the Insurrection Act are arguably missing or vague and unclarified in subsection 2 of 253 of the Insurrection Act. And before we get into Collins, any questions on Insurrection Act? There is an opinion that was issued by, I think, a deputy attorney general in the 60s that suggests that, the predecessor codification in 333, right? And I'll read this. Sections 332 and 333 appear on their face to confer broad authority whenever the president deems it necessary. They are limited by the Constitution and tradition. Thus, the constitutional basis for the use of 232 and 333 in connection with racial disturbances for the only federal law involved in such disturbances is that amendment in the federal statute or court orders, which are directly or indirectly based upon it. The amendment is, of course, directed at state action and does not normally apply to the acts of private persons. So that's perhaps how I would read it, right? As having a basis of legislative authority in the 14th Amendment. That would be a kind of way to read it. But Article 1 gives authority to the Congress to set forth for calling forth a militia. So while I agree that traditionally this is how it's been used, I'm not convinced that that's what the court will say is required, or that Congress is limited to its legislative authority under the 14th Amendment as opposed to Article 1's calling forth authorities to somehow tailor the invocation under 253, then 333, to some kind of state action or inaction with respect to animating concerns of the 14th Amendment. Yeah, it's a different Breyer. It's his brother. Yeah, wow, that's extremely concerning. Great fine. I just tell you, I am the Lorax. I speak for the trees. Why do you think Breyer omitted an explanation of this section? I think probably because, look at what he says. He says the Insurrection Act imposes meaningful guardrails on the president's authority. He construes it as 3 avenues. And I think that recognizing that 4th avenue is a little bit undermining, assuming that he has a different reading of it. Or sorry, the same reading that maybe a broad interpretation would be, that it would undermine his point about meaningful guardrails, because what guardrail would that be? And maybe he doesn't want to wade into that interpretive work. This is crazy. Breyer spends a lot of time saying what it's not, but it doesn't precisely define when, if ever, the president has inherent constitutional authority to use military domestically. Right, but that's not really at issue. The issue is whether or not he can use it to enforce civilian law, that's the issue is before him is whether there's a violation of posse comitatus. Now, if there was a finding that everything that they were doing was allowed under military authorities, then there would be no posse comitatus. Like if none of this was enforcing civilian law, then you're right, no posse comitatus. But he does find that they're enforcing civilian law by some of the actions that they took. So he doesn't need to have a full distillation of all the times that military domestic usage is justified in order to make at least a preliminary finding that the military was at least used some of the time to enforce civilian law. And once you've done that, you've made out all you need for posse comitatus to apply. I'm guessing he was asking for Congress. No, I mean, he doesn't even address it. And that to me is telling. I think it's telling of uncertainty and lack of clarity. And yeah, it's a problem. If I had it my way, I would just get rid of sub 2 or clarify sub 2's scope or interpret it as this deputy AG or whatever did. Deputy Attorney General Katzenbach. This is to President Johnson, I think. And this is during Vietnam. Cool. Any final questions on Insurrection Act before we get to Collins? Collins. And right now I don't see any Collins. I know that we have one person who wants to call in. And that I think is, what's her name? Icy Beans, that's it. Ice Beans. But final questions on Insurrection Act. You missed the explanation of 252 and 253. You can just go back. What's great is the VOD is available and you can go back. And I might even make like a little edit of it. What's the Discord link? You can go !Discord. And I think it's like discord.gg/peacecord. Can Collins be about anything? Not about anything like anything. There's some things I won't talk about, but within reason, yeah. You can ask stuff. We prefer disagreements, but you can ask questions too. I don't know why this command stops working. It's so annoying. Maybe I have to like pay. I think I already pay. They're scamming me. I think I already pay. You found it? Cool. Is this going to be on the test? You betcha. All right. I see Ice Beans. She requested first, and so we'll move her into live. What up, Ice Beans? How you doing?
Howdy. How are you doing?
Doing well. Good to hear from you.
Good to hear you. I've been okay. So I'm I'm not gonna lie. I've been losing my mind a little bit. I've been watching your Chud debate, and we had a couple. I have a couple of questions essentially. Here, let me hide this real quick. So and we haven't finished it, so maybe there's going to be clarifications coming, but we're halfway through it. Mm-hmm. So first of all, when y'all talk about threat of deadly force, right? Mm-hmm. Does that include, is intent factored into that or no?
So it's no and yes, and I'll tell you why.
Okay.
So one of the elements or one of the considerations for the sort of test expounded by the Supreme Court isn't the specific intent of the person who is the subject of the force. Okay. So formally, their intent is irrelevant. But here's how it is relevant in the meat and potatoes. That someone's perceived intent, right, as a reasonable officer will apprehend, plays into whether a use of force is objectively reasonable. And this is obvious, right? That when making assessments as to threat, when making assessments as to the use of force, how one perceives the intentions of others is critical. If someone is holding a gun and you know, or you have a good reason to believe they're about to pull it out and shoot you, well, let's say they haven't done it yet. If that basis of belief regarding another person's intent is reasonably justified, then you'd be justified in using force, even if you were wrong about the intent. So the actual intent is irrelevant, but a reasonable officer's perception of intent, of course, is relevant. And so, yeah, that's what my response to it.
So essentially, it's not. Okay, so it's essentially if you're taking on the, just to kind of rephrase of what you if I understand you correctly, when you're looking at the subject, which would be in this case the the ICE officer who shot,
right.
You're saying, did he interpret her actions to be a threat? Okay, so I guess part of the reason I asked was because one of the analogies that my chat brought, or that we were talking about, was like if you walked in front of a moving train, right? I was saying that, like, of course you would perceive yourself to be under threat of bodily harm, but because the train itself isn't, like, it's not like the conductor is driving the fucking train at you. So, does that count? Do you know what I mean? Because it's like a moving train that would have already hit you regardless of the intent of the conductor, right?
Yes. Sometimes intent won't matter at all, or perceived intent won't matter at all. In the case that you're suggesting, it's unclear how the perceived intent of the conductor in that hypothetical would be relevant.
Right.
But there's an additional point there, which is that in that train example, shooting the conductor
wouldn't stop.
And an officer would, and just to be clear, it's not that it wouldn't stop it. It's that an objectively reasonable officer wouldn't think that it would stop it. The threat. Assuming the threat is, you understand, right? So it's not the actual, but the actual informs, and the policies inform, and the training informs what an objectively reasonable officer would think.
Officer should have done. Right.
Yes.
Oh, should think as well. Not just should have done.
Right. Not just should have done, but should have perceived. Right. Like, it's not just that the use of force be tailored in some actual sense to a threat that actually occurred, but that an objectively reasonable officer would think that, right? If you just shoot, follow me along here, right?
Yeah.
An officer shoots randomly into a crowd.
Yeah.
It turns out, in the biggest stroke of luck of all time, that the person that was killed by the officer, again, randomly shooting into the crowd, was an assassin whose only job was to kill the cop. Okay? Would you say that use of force was reasonable?
No.
Of course, right? Because even though, in point of fact, not only was the use of force effective at getting an actual threat to his life, but not only that, it was successful, and everyone is happy, right? You just killed an assassin. But an objectively reasonable officer in that officer's position would not perceive that threat. And actually, here the subjective component plays into it as well, which is it's both an objective and subjective test. That the officer in their position didn't actually perceive the threat. He just shot randomly. And of course, even if it's the case that the result is happy, happy sunshine, that doesn't mean the use of force was reasonable, right?
Right. Okay, so then that kind of actually leads me into my sort of second question, which is that now we've obviously, well, okay, to be clear, this is where I am in the debate. you just basically like raped him over the, you brought up that
be careful.
hypothetical.
Listen.
Yeah.
Be careful
So, yeah.
with the terminology. I'm not sawing
But-
out. It just
Yeah, fair enough. No, that's fair.
No,
No,
let me
that's fine.
explain
No,
it.
I'm
Let
not-
me explain it.
Yeah.
I'm not just sawing out. The last
Okay, yeah.
when Chud did that, the entire video got 18 plus.
Oh,
and
bro. Okay,
demonetized.
I'm sorry.
Yeah,
okay,
no.
no. Okay, I
That's the only
apologize.
reason.
I
Yeah.
apologize.
It's
Yeah,
cool,
I
it's cool.
apologize. Okay, yeah. So, no. So, okay. So you just you tried to bring up the, I would say, reasonable enough hypothetical of the North-South thing.
Yep.
Right? He soyed out, and
Yeah,
then you brought up the the Watchmen thing, and
Yep.
then y'all played chicken, and then he lost the game of chicken, and then you went in, and he basically, I'm not gonna lie, I saw the light of realization that he
Yeah.
was wrong, and then it led into a whole other thing with him calling you DDD, blah blah blah. I don't have to
Yeah.
get into it, but basically that's where we were. That's where we kind of are, right?
Yeah.
But one thing that and let's be real, I know that with Chud, it's objects. It's not, you're not going in there, or at least I don't think that maybe you should go in there thinking that there's going to be a nuanced discussion. But going back to my original question, right?
Mhm.
Does him, like, okay, so the officer putting himself in that position, right? Because we know, according to DHS guidelines, he shouldn't have approached the car in that way, and he shouldn't be shooting at moving vehicles like this, right? I could be wrong. I'm pretty sure
I think
that's
you're
the
right.
guidelines, right? Now, would those have a bearing on whether his like use of force gets deemed like this would be what an objectively like reasonable officer would do? Like, does that have any bearing on that? Or is it considered
Unclear.
like independent? Oh, okay.
And the reason it's unclear is, well, at least with respect to some things, I think that it is relevant for purposes of assessing whether or not the use of force was itself reasonable from the
Mhm.
perspective of the officer's intuitions and what an objectively reasonable officer would feel would have a tendency to eliminate the threat.
Mhm.
And it would play into what an objectively reasonable officer would do, namely their training, and their training is at least in part informed by their policies. So I think it's relevant in that respect. What is unclear is the broader point about officer created hazard. That is to say, regardless of the policy violation, and I'm assuming policy violation would play into the evidentiary case for whether or not there's an officer created hazard, the Supreme Court has not yet ruled definitively on whether officer created jeopardies by itself has some relevance to the analysis. That independent of the policy violation for purposes of establishing what is reasonable with respect to the use of force, that putting themselves in that situation, right? Understand the difference there? One is
Yes,
the use
they
of
just
force
have
reasonable
not.
vis-a-vis
Yeah,
the
okay,
policy.
hold on.
Yeah, go.
So basically, you're saying like whether. Sorry, I'm just trying to like parse what you said.
Let me explain it a different way,
that-
okay?
Okay, yeah. Go
So
ahead.
the policy could be relevant to, is the use of force justified? Because the policy might inform an objectively reasonable officer's perceptions about what use of force is reasonable. Okay? That's
Okay,
one.
okay.
Use of force.
Okay.
The policy might also be relevant, though we're not sure yet, as to whether the officer created an unreasonable officer created jeopardy, hazard.
Right.
So use of force and the entire policy affecting his decision to create the hazard in the first place, that we should take a negative inference against him. So it's a nuanced difference. The use of force versus officer created hazard. I think it's clear. Excuse me. Sorry. I think it's clear. Shout out Word War Debate. Thank you for watching. I think it's clear that the policy is relevant for the use of force. Relevant. I don't say dispositive, right? By which I mean it doesn't decide the case. Just because he violated policy doesn't mean that he was unreasonable as a matter of law. That would be absurd, right? Because it would be absurd because imagine Trump writes a different policy and it's just like an absurd policy. But it's unclear whether it's relevant to the officer created hazard doctrine. Does that make sense?
So you're saying it's just not like it. There's no necessarily like there's no precedent there's nothing that you can rely on to say yes it has a bearing or no it doesn't.
I think it
Is that
does
kind
have
of-
a bearing on the evidentiary case for whether the use of force was justified. And there's precedent of that. And again, I'm gonna use the Chauvin case just because people know it.
Okay.
In the
Yeah,
Chauvin
mhm.
case, you'll remember there was a bunch of evidence presented about Chauvin was taught this technique or he wasn't taught that technique. Now, I don't go so far as to say whether he was taught it determines whether it was reasonable, because that would, I think, structurally be wrong and silly. And it's also not true that like the police get to regulate themselves in that respect, such that it informs the legal test, or at least determines it. So evidence, I am representing that the policies are relevant for the evidentiary case, for sure. What I'm saying is uncertain is to another argument, namely the officer-created jeopardy doctrine, and whether
Okay.
that is going to be upheld by the Supreme Court. Less clear. They've left that open.
I see. Okay, I see. Okay, so okay, when you say okay, I was gonna ask you to clarify the evidentiary thing, but you're just talking about whether or not it was okay, essentially reasonable for him to use that force to, okay, all right,
Right,
versus
so
the
policy-
officer. You
yes.
said okay.
Policy violation definitely relevant for the evidentiary case for use of force. Unclear about whether or not officer-created jeopardy is even a thing we should consider. And so, in virtue of the fact that it's unclear whether that doctrine itself is relevant, unclear whether the policy violation is helpful for that determination.
Now, do you think that in that sense that it should be brought up?
Yes.
So that they at least like we would get a ruling one way or the other.
Yeah,
kind of?
because
Is that kind of
I think that a use of force. Imagine I always go to the ridiculous hypothetical to try to prove the principle. Suppose that an officer jumps into the middle of the street in a highway such that like there's no reasonable way for a driver who's being
To
at
stop.
least minimally competent to stop, and he just shoots him and he creates the hazard.
right?
How would the Constitution protect such an action? And the answer is has to be no. It can't be
Yeah.
the case that we would allow that bad faith or grossly reckless conduct should be not considered as an
Right.
analysis of objective reasonability from an officer perspective. Now, do I say in every case an officer does something negligent or reckless, therefore not reasonable? No, I don't say that. But I do think that it should be at least relevant. And so that's my position on it. What the Supreme Court will say, unclear.
Do you wait? I'm gonna be honest. I haven't looked at this in a little bit. So like, is this even being like? I don't think they've said they're not going to investigate. Or at least
Who's they?
hold on, maybe I'm mistaken. Didn't Republicans like vote to like not investigate this, or am I misremembering it? Like, would this case get to any level of like near even the Supreme Court? That's what I'm trying to ascertain. I might not have
It
the
would
background
require
on
some
it.
kind of legal proceeding, either
Right, that's what I mean, sorry.
a civil case involving the estate of the decedent, and then you'd have the additional burden of qualified immunity doctrine, or a criminal case of some kind. And what you're referencing in terms of the administration is that they have signaled that they're really not going to look into this case from a federal perspective. But I don't think
but there's no reason somebody couldn't, like her wife, for example, couldn't bring a case. Okay,
or the
okay.
state.
So
In my opinion, I think the state has the authority and jurisdiction to bring a criminal case against the officer. Whether they will, unclear as well.
Okay. Okay. So then I will then hold my like. Okay. Then the last thing that I think, this is more of like a, I don't know if it's like outside your scope at all.
Mhm.
Okay. But I'm just curious. Okay. So something that I noticed when you were talking to Chud. Okay. This was when he characterized, when he was kind of describing, he said that describing the general situation, he said that like, essentially the temperature of the political climate is making all of these like protesters like engage with ICE in these ways, and then ICE is responding in kind, right?
Mhm.
And something that, and even somebody in your chat just said this in a like a little bit ago. Okay, so basically, he said it in a way that I think betrays the way that he perceives this all to be. Essentially, like, these are protesters who are antagonizing ICE officers, right?
Mhm.
He's not considering at all. Well, for sure, I don't know if you get into this later in the debate or not. He's certainly not considering DHS policy. But also beyond that, he's not considering why the protesters are there to begin with, or the the tactics, the specific thing that ICE is doing, which is they are there, number one, but then also that they are employing these tactics that are causing unrest in the community and breaking trust in a community, and, like, complicating the relationships between the community and the law enforcement, right? He doesn't care about any of that, right?
I think that he views it, to be fair to Chud, even though he's not fair to me, I think he views them, as I do, as minimally probative. Because he did say he takes the position of fuck ICE. He does say that in the debate at some point. I forget when. So
he says it, but I think my problem was that when he then went ahead and described that situation, that was how he described it. Was that, yes, he made a gesture towards the temperature of the situation, but he phrased it as protesters
have the exclusive role in the causality for the bad stuff.
ICE are causing, ICE are responding in kind. And the in kind is not the problem for me. It's the point that where he thinks that what he thinks is as the chicken or the egg. You know what I mean?
Mm-hmm. Yeah, no, I understand
yeah.
that. Sorry, continue.
Oh, sorry. Yeah. So basically, my sort of frustration, and this is not with you at all, by the way, okay? Because I understand that what you are there to do is to argue, like, the legal nuances of the actual shooting in and of itself, right? Like, that's what you're there to do. That's what you're, like, knowledgeable on. And let's be completely real. Chud is just about as qualified as I am. I'm just a shitter, like, so. My question I guess this is more of like an expression of frustration, is that sometimes I feel like the conversation gets brought to this very specific, like, line. Is it legal or is it not? And none of the consideration is given for, like, any of the preceding factors, because, again, not a lawyer, don't have any kind of knowledge on this. I feel like all of those things are relevant when you're talking about the actual shooting itself, no? But maybe I'm wrong on that. I don't know.
I think that for the legal case, I think that they're minimally probative, because it really is a kind of fact-specific inquiry. And yes, I would say the general demeanor of the protest is relevant to what an objectively reasonable officer would perceive. I don't say it's irrelevant. I just want to be clear about that. But it's not necessarily highly probative to the case. As to the broader frustration... Go ahead.
Yeah, no. I was gonna say the case itself, like the arguing the case itself. And when I say that I feel like it should be relevant, I don't mean that it should be relevant to the legal case.
It should be spoken to. It should be addressed.
I just
it's
think
an elephant
that,
in the room.
Yeah.
Yeah.
I think it's an elephant in the room, and I don't like it when I guess I don't like it when it is dismissed in that way because it's not relevant. Because it's not factually relevant to the case. Therefore, we don't have to look at it at all. We don't have to address it at all. And I feel like sometimes that is used as a way to kind of sidestep all these questions that we should be having about ICE, right? Or that we should be having about what ICE is doing. I think that's my frustration with it, right? I understand it's not your realm necessarily, because you're not.
Well, I think it is. Yeah. So
okay.
But I can speak a little bit to that. First of all, I understand that frustration. And it seems preposterous that we have to have a more kind of narrow inquiry into this issue when so much bullshit is coming from ICE that we're not even, like, looking at the big picture, that people can get the sense that we're missing the forest for the trees. I understand that. I respect that. I don't think in my broader coverage I miss the forest. And the reason for that is, like, for example, the other day we looked at a lawsuit. This might have even been yesterday. about how ICE, in their use of tactics against protesters, was specifically found in federal court to have done so for the purpose of retaliating against First Amendment protected activities. That is to say, they are breaking wedding rings, they're gassing people. What the court found on a preliminary basis was that this was done to retaliate for First Amendment protected activities.
Interesting. Okay.
To say nothing of the pretextual racial stops that happened in California and that continue to happen across the country. U.S. citizens who are being detained with no good basis. There's a video, I think, of a nice officer saying we're holding you because of your accent or something approaching that. So,
okay.
And in my coverage broader, I think I talk about ICE's infringements in that respect. But I understand the frustration because in this conversation, you can hear me kind of poo-poo some of the concerns, right? I poo-poo the concern of, well, do they even have authority in the first place? I'm like, I don't really think that matters that much of this discussion. Right. And someone who listened to that, like, wait, I want to talk about whether or not ICE has authority in this role.
Right.
I want to talk about whether or not they should even be there in the first place. You can disagree with this tactic, and you tell me what you think. I think that we're winning the conversation with respect to the self-defense and shooting thing, and it's a good optical position to have conservatives on the back foot discussing the discrete use of force. I think it makes them look unhinged, and I think broadly the public is on our side. And I think that if I start soying out about broader ICE concerns, I don't know that that's a good look for me in that context.
With
Chud, where I'm like fighting to narrow the conversation. And so me broadening it to talk about like other policy and constitutional concerns feels like an invitation for Chud to wiggle away and dodge and look less preposterous. You tell me.
No. Okay. To be clear, I'm not disagreeing with anything that you said right there. I think that is like you in that case with Chud, and even more broadly as like your own, like even if you never broadened it out, that's not what I have. Like, no, I don't have any issues with that, right? Cool. The fact that you do broaden it out is like, for me, more of a bonus because you, okay, for lack of a better way to say this, I see you as having like a very specific role in the space, right? So for you to be filling your role is all that I need. You know what I mean? Like, I don't need you to expand it. What I'm more so, I guess where my frustration comes in, or rather like where I would want to go with that, is to kind of invite people to see when that line is being artificially drawn to, like, it's being artificially like forced to like the very legal, the immediate facts of the case. Is he justified in shooting when it's appropriate to broaden the conversation? That's what I mean, right?
Yeah. So
like that's all I mean. I'm not saying that you should do that. This is more of a case of like, because let's be completely real, like Chud is, and again, don't think that you should have done this with Chud. I agree completely with the approach you took with him. Actually, no, I do have one thing to contest with you on that, but that'll be my final thing. Okay.
Sure.
Like, I'm saying outside of this context, right? Outside of this context, I want people to be aware of when that is being forced upon them, and they should be asking that broader question of, why was ICE there doing the tactics that they were doing? That's really all, I guess.
No,
it's not so much,
I get that. And people say that similar things when we were doing these like insurrection debates about whether Trump engaged in an insurrection. Like what sometimes they will say is like, well, who cares if it's definitionally an insurrection or not? It was bad, right? Isn't it? Can't we just say it's bad? But I think sometimes these labels matter insofar as they have legal consequences, and certainly in terms of what we would criticize our government to do. And so because I think, right, like if I didn't find this to be probably murder, I wouldn't be calling on the Minnesota officials to charge him with murder. And so I do think that there's a self-standing, like analytically rigorous requirement that we determine if we're asking our officials to do something, whether or not we agree with it. And I think that's a value add that I provide. But I do agree with what I'm taking to be your core point, namely that when we're in broader discussions and more open discussions, we should make sure to mention that the abuses of ICE and of this government aren't limited to the facts and legal determination in this case. And that even if it was found that this wasn't murder, and even if I was convinced this wasn't murder, it doesn't mean that what was happening was responsible from ICE. Doesn't mean people shouldn't be fired, and it doesn't mean that the administration should like keep lying or shouldn't be accused and negatively sort of have consequences because of their conduct from a broader sort of policy perspective. And so, to the extent that that's your core point, I'm in agreement with it.
Okay. Okay. Last thing, I promise.
Yep.
So now, correct me if I'm wrong, right? You had like watched a clip of Chud, and then you kind of more or less issued like a challenge to him, and then you kind of went in, like, then y'all set up a conversation and y'all had the conversation, right? I'm genuinely curious, like, did you think that it was going to be like nuanced discussion, or do you think it was going to be like complete optics things? Because I feel like I feel like I got an impression that you did think there was maybe a nuanced discussion angle that y'all could take, and then you had to kind of then it felt like I felt like you realized, oh, this is what the situation is. Okay, it is optics. So then you did what you could. I'm just curious.
You're asking me what my impression of what the conversation would turn into before I had it?
Yeah.
I don't have a high opinion of Chud's analysis on these issues.
Of course. That was the other thing I was going to say. And
I don't
sorry.
view him as having a kind of like rigorous analytical mind for approaching these problems. And I don't think that he's someone who you can rely on to work in good faith with you to the end of having a fruitful and whatever conversation. And so I think you can tell by my demeanor initially that I'm trying to signal to the audience, and I'm also feeling like a sense of just like, we're shooting the shit kind of deal. That said, just because I'm like not sold this will be like a very good faith conversation doesn't mean that I'm not going to approach it from what I take to be an analytically rigorous perspective, at least in some respect. So I think being sometimes too stiff might hurt the optics, but I was trying to push in a particular direction.
Yeah. I think no. To be clear, I think that you did well with what you had. I'm not gonna. So far, right? I just what I was critical of you in the beginning was that you had dropped a spicy challenge on him, right? And then when it kind of seemed like you were going in like you would go into a discussion with, like, say, Hutch, for example. You know, like, you're there, you are ready to, like, discuss the nuances, and then he was going full spicy, and then you had to, like, it just seemed like that. That's all I'm saying. I'm not saying that, like,
I just reacted. So when you said the challenge, I was at Word War Debate, and I saw a clip where he was like, it's political. I'll just think that he's political. And I was just saying, like, if I like any one of these motherfuckers to have a conversation, whatever. I didn't like personally invite him to do it. He reached out to me and I'm like, yeah, let's do it. And my inclination was it would turn into this kind of like more like this farce. And I don't really think that I didn't like watch any of his shit though.
I see what you're saying. Okay.
But I could tell very quickly when someone is trying to get into like specific contradiction as opposed to giving their take on the incident, right? So what he started with was not, this is why it's self-defense. What he started with was, you were incorrect about X, right? And so the minute he started with that, I already knew it was off the rails, because that is a telltale sign, in my opinion, of bad faith. Rather than approach the proposition, whether this was justified, whether it's murder, he's trying to score some sort of take on a specific contradiction that I was like wrong. That the proposition is now I'm wrong, as opposed to
wrong. Yeah.
This is an issue which has a particular result. And it's funny because he was wrong and his own point disproved it, and he fell on his face.
Yes, he did.
The minute he started with that, I'm like, okay, this is a shit show. So it was even before all that other stuff happened. It's just how he framed it initially. I knew that he was not approaching the conversation in good faith. And I will say, yes, he is a bad faith interlocutor. He is not operating in good faith. That doesn't mean I'm never going to interact with him again. I interact with people who I think are bad faith operators. I'm going to be honest. I like Ryan Mullally a lot. I think he is a bad faith debater. I do. I think that he is dishonest in his debate.
You just have to know how to deal with them.
Yeah,
you just have to know how to deal with them.
But I still can find the conversation useful for my own purposes. But yeah, I do think that Chud is dishonest in how he approaches that conversation. And very quickly, I thought that was what was happening.
And that's fine. I think I'll stop the glaze fest. But basically, like, I think that was the way you essentially reacted to how he was approaching this was fine. I just my criticism was only like, well, you did issue a challenge, and so then he came in like guns rearing. That literally is the only like extent of it. It really does not have any teeth. But yeah, I'm gonna finish it to see if there's anything like any more like interesting things that we can take out of it.
Sure.
But yes, I do agree that he's so far made himself look very, very silly.
I agree.
I guess my final question is, like, if there is a civil case, or sorry, if there is a case that is brought up against this, right? Just with how like the Supreme Court has been, I feel like they've been very flip-floppy in terms of like whether they uphold like Trump's leanings towards things. What would be your intuition as to how they would rule for the officer, like, what did he call it? Like the officer induced jeopardy. Like what would be your like
I think that all else equal, I think that they'll include it as part of the analysis.
Okay.
But that doesn't mean that Minnesota would win in a case against Trump. And you've already sort of previewed the ways in which that could be harder by mentioning like a civil damages suit, where just because they find it that, officer created jeopardy is relevant, doesn't mean that in a suit involving qualified immunity, where there's like this additional burden to show that not just the action was unlawful, but that it was like clearly unlawful. I'm not convinced that, for example, in that context, that the Supreme Court would side with the state of Minnesota or with the state of the decedent or whatever. So in that, there are many different contexts in which this fact pattern could be presented to the Supreme Court. You could imagine there could be a federalism issue. Are you allowed to charge a sitting line officer as from a state government perspective? I heard JD Vance, and if you watch my appearance with Crystal and Kyle tomorrow, you'll see us talk about absolute immunity for line officers. And so I think that it's possible that the Trump administration could bring the absolute immunity argument for its lower officials. And it's very, very dangerous.
They're trying. Okay, I see. Okay.
And that's what JD Vance is invoking. And so there are a bunch of different ways in which this fact pattern could make its way to the Supreme Court in different discrete areas. And so that's, let's not try to prejudge how it will happen.
Yeah.
But on the specific point that you bring, I do think it's likely that the Supreme Court, I don't say like huge chance, will in some capacity say as a totality of circumstances, you consider officer created hazards.
Okay. Yeah. I mean, like you said, I understand I'm asking a question that's like a wild hypothetical that has basically no information, all right?
Yeah.
But I'm also trying to basically like temper my expectations as far as like what would happen going forward from here. Like I honestly expect there to not be a case, or a case that goes anywhere. So I think it would be good if, like you said, the officer induced jeopardy does play a part in the analysis of that, whether it's legal.
Yeah, there are a lot of hurdles. There's an evidentiary hurdle with the federal government trying to conceal its investigation from state authorities. There's the threshold questions of state versus federal. There's the question of whether the state has the desire to charge this individual. There's their interpretation of the facts as we know them. So the only thing I'm commenting on is what I think and what I think the evidence show. And what I think the evidence show is a murder in in daylight from a cop to
Mm-hmm.
a civilian.
Yeah, fair enough. All right, that was more or less it. Thank you for having me. I'll
Yep.
talk to you soon, I'm sure.
Thank you so much, Ice Beans. Everyone follow
All right, have a good one.
Ice_beans. Thank you so much.
Oh, thank you. I appreciate it. Have a good night.
Later.
Bye.
All right, next caller. What up, Ryuk? Ryuk? What up, man? You're muted. Or woman. Or non-identifying.
Sorry about that, my bad.
Oh, hey, what's up?
Hey, so I have a question concerning, I had two questions actually. One concerning scope and the other concerning training. So I think you already touched on this earlier about how you don't think scope is going to be brought up whatsoever in terms of what ICE is doing.
When you say scope, you mean whether or not they have the authority to do some of these actions like stopping people?
Yes, whether or
Okay.
not they even have the authority to approach citizens of the United States.
Yeah.
Are you saying yes, as in
Yes,
they
I
do?
think they do. Yes. You were like setting something up. I didn't want to interrupt you, but the answer is yes. I think they, in general, have authority to approach U.S. citizens and detain them for some things.
For some, and what do you mean for some things?
So, under the Immigration Nationality Act, the DHS officials, by its terms, the INA will dedicate this to like the Attorney General. But we shifted responsibility from DOJ to at least concurrent authority with the DHS. And so just understand that when there's reference to the Attorney General in the INA, but the INA makes clear that like immigration officers are allowed, and I'm going to pull it up while you continue to talk, that immigration officers do have authority under the US law to make arrests for crimes against the United States. So not all crimes against the United States, any crime against the United States, when it's done in their presence. So that's
right under that
the hook.
Oh, sorry.
Go for it.
So under that subheading, what is against the United States? What does that entail?
That entails federal crimes. So when the federal crimes are crimes against the United States. So like, right, because when you have a case like U.S. versus Trump versus the United States, those are cases in which the aggrieved party is the government, and it's similar context in like a state crime situation. You'll hear, the people of New York versus Trump, or the people versus OJ, right? So in that context, a crime against the United States government is a federal crime.
But under what purview does an ICE officer have to conclude that the person is committing a crime against the United States versus just a misdemeanor? Especially if the crime isn't directly against them and they're not impeding in such a way that they would be allowed to approach them.
So the arrests don't specify felony versus misdemeanor. That's the first thing to note, right? And the limitation is the same constitutional limitation, namely reasonable suspicion when it comes to quote unquote Terry stops. And this is from a case Terry versus Ohio. And for arrests, full arrests, it's probable cause. But I'll just read, and then you can ask more questions. This is 8 USC 1357. Sub A, powers without warrant. Actually, I'll bring it up actually so people can see it. One moment. Also, these are great questions, by the way, so appreciate you asking them. So it says, powers of immigration officers and employees, powers without a warrant. So there's no like warrant in this case, but it says any officer or employee of the service authorized under regulations prescribed by the Attorney General shall have power without a warrant. So this is the reference that I say, keep in mind there's like a catch-all statute that like transfers at least concurrently some of this authority to the DHS. So don't be dissuaded by that. This probably applies to ICE as it's currently formulated. Just that the INA was like written before the DHS. And then sub 5, to make arrests for any offense against the United States if the offense is committed in the officer's or employee's presence, or for any felony cognizable under the laws of the United States if the officer or employee has reasonable grounds to believe the person to be arrested has committed or is committing such a felony. So in those cases, they have the power without a warrant to make such arrests.
It says felony though, right?
So sub B says felony, but sub A says for any offense against the United States if the offense is committed in the officer's or employee's presence, or for any felony cognizable under the laws of the United States if the officer or employee has reasonable grounds to believe the person to be arrested has committed or is committing such a felony. For any felony.
Right. And we established that any crime against the United States is on its face a felony.
No.
Or is that not the case?
So there are crimes against the United States which are not felonies, misdemeanors. So
okay.
Something can be, and that's why they made these two different parts, right? So there's a rule for in general, if you see any federal crime in front of you, you're allowed to arrest, regardless of whether it's a felony. And then there's a special rule for felonies, sub B, that says for any felony cognizable under the laws of the United States, so it has to be a federal felony. It's not just if it was committed in your presence. It's if you have a reasonable ground to believe the person arrested has committed or is committing it. So you have additional authorities if you think it's a felony, that it doesn't even need to be in your presence.
Okay. Gotcha. So just to summarize, in their opinion, if you're committing any crime against the United States, which to them could be, I'm not sure, impeding or standing around or stealing, I don't know, would like petty
let me make
theft
your case,
fall under that?
So probably not. So let me give you what you want. Here's what's tough. What is the requisite crime against the United States? Because the typical crime that they're trying to use in these contexts involves the deployment of force against to prevent or obstruct. It's not just obstructing that they're charging a lot of people, but forcibly obstructing. Okay. And so there's a interpretive question about whether or not causing these sort of traffic incidents constitutes like forcible obstruction of some kind. So maybe there's a legal question there. That would maybe be like one of the stronger cases that you might have, that like, okay, there's no authority to make this stop because it's not forcible obstruction. It's maybe some other kind of obstruction. But I believe there are other statutes on the book that allow for other kinds of obstruction. I'm not sure, as I said here, what those are. So we would have to like look at what the proposed basis of the stop is. And that's why I'm like assuming that there's something on the books that involves some sort of obstruction of an immigration proceeding. But because even if I granted that they were without authority to make the stop, I don't think that determines the legal issue of self-defense or use of force. Because of course there can be illegal stops without probable cause or reasonable suspicion that don't determine whether the use of force is justified. Like you can imagine an illegal stop and then all of a sudden some bad guy pulls out a gun on an illegal stop. Would the cop really not be authorized to shoot back? And so that's why I've been sort of shying away from the determination. I don't claim that I know it's authorized. I suspect it's authorized. But yeah, I'll let you respond to that. I put a lot there.
Yeah, from my understanding, they're not supposed to approach from the front of the vehicle anyway. Mm-hmm. That's why they're supposed to approach from the back of the vehicle, I think like the side specifically. And in that case, he actually got out of his own vehicle to stand in front of her vehicle. So like there's a clear video of him actually exiting his own vehicle. So he put himself in direct harm. Agreed. But another thing that, the other thing that I take into question is training, because, and this isn't really well defined, but I heard that a lot of the officers were not actually properly trained. They weren't, because under their training program, it says that they are only allowed to use their own weapon if they receive proper training to do so. And I think it's under, I'm looking at 287.8 standards for enforcement activities. This is the Code of Federal Regulations.
CFR.
It says under...
Is it like 8 CFR what, something?
Yes, 8 CFR 287.8, I think that's what it is. I'm sorry, I don't know the exact legal...
So just so you guys understand, these are promulgated regulations from the executive branch itself. And oftentimes they can be held to them as illegal. Like even if it's not like written specifically in the statute. Oftentimes, from like a due process perspective, at a bare minimum, they are obliged to comply with their own regulations, right? It would be kind of weird that they wouldn't be, right? So I've shown 287.8 standards for enforcement activities, and you want me to go to which part?
I want to start a use of force. There's non-deadly force, so I want to start with non-deadly force. I want to read something specific from paragraph 3. It says, let me know when you're there if you just want me to read it.
This is little Roman numeral 3?
Yes.
Yep.
A designated immigration officer shall always use the minimum non-deadly force necessary to accomplish the officer's mission and shall escalate to a higher non-deadly force only when such higher level of force is warranted by the actions, apparent intentions, and apparent capabilities of the suspect, prisoner, or assailant. Which brings into question his initial actions because he gets out of his own vehicle to step in front of hers. So I'm wondering if that kind of implies that non-deadly force should have been used in the first place.
I'm not convinced that stopping in front of the vehicle is considered the application of non-deadly force, and so that's why I'm not sure. I would definitely agree that there's like a proportionality component to the use of force, but I'm not sure why. I would grant to you that the stopping in front of the vehicle and persisting to be in front of the vehicle and approaching it from the front is a violation almost certainly of policy, but I'm not sure how it relates to this subsection, because I don't think that those actions by themselves constitute the use of force.
No, yeah, the force on his part. But the other thing under it that I kind of want to also is, I mentioned training. It says a designated immigration officer. So, I'm sorry, I read the wrong thing. Under 4, the following immigration officers who have successfully completed basic immigration and law enforcement training are hereby authorized to designate to exercise the power conferred by Section 287 of the Act to use non-deadly force should circumstances warrant it. So under that section, I'm wondering if even the training of the officers is going to be brought into, because if I understand, they're being kind of pushed through these training programs pretty quickly. They're not exactly being issued weapons. They're being told to use their own weapons, and there's even special training specifically for that. So, like, is there a possibility that they're going to be going through these officers' trainings and kind of seeing if they're actually completing them properly?
Doubtful on the specific case. So, and there's some other legal proceeding where it would come up for a couple of reasons. So, first, to note that 287 of the Act, guys, don't be confused. That's a reference to the codification from the Immigration Nationality Act perspective, not the U.S. codification. So don't be confused when you see, for example, INA 287 sub A. That's a codification within the statute. It's not necessarily how it's codified in the U.S. statute. So just keep that in mind. And different, for example, the Supreme Court will often use the statutory references and not the INA references. So that's just a little, the more you know thing there. But the guy in question in the actual shooting of Renee Good has been employed with ICE, I think, for either something close to a decade or some shit. And so I don't think that it's reasonable to think that he didn't complete the necessary law enforcement training. And I think he also might be like a veteran. I'm not sure how that relates to the case. It definitely bears where I would absolutely give you your flowers on the overall irresponsibility of the regime and the crazy shit they're doing is basically asking for some fucked up shit to happen. I think they're even using AI to check people's shit. It's fucked up. So, I agree with that. I just don't know if it's relevant to the specific Renee Good situation.
Okay. There was one more thing. It was under, I just lost it, under general procedures. This might be in a different part. I have this copy and pasted
This is
somewhere.
The conduct of arrest, sub C?
Yes.
Okay.
It says in 1, an arrest shall be made only when the designated immigration officer has reason to believe that this person to be arrested has committed an offense against the United States. I'm sorry. Yeah, so that part. And then it says on 3, at the time of arrest, the designated immigration officer shall, as soon as practical and safe to do so, identify himself or herself as an immigration officer who is an authorized to execute arrest and state that the person is under arrest and the reason for the arrest. So I don't recall in the video him ever identifying himself. Is that something that I missed?
I don't. He probably didn't, but you know, the devil's in the details.
Okay.
As soon as it is practical and safe to do so, that's going to be a question. And again, I even assume that he violated this policy, which maybe he did. I'm not sure that I would require the officers at the point in which they're literally getting in the car to try to stop and to bring her out of the car, that they've yet gotten to the situation in which it's practical and safe to like give them the reason for their arrest and do all the procedural stuff. But even if I did, I think that it is not that relevant for purposes of the renegade shooting. But once again, to the extent that you're making the point about like this whole hiding who you are, people who are being like abused because of fake ICE agents, that's happened, that it's a horrible reflection on the administration and what they're like doing in terms of irresponsibility. And it probably will lead to more situations of mistrust and flight from people who are just like scared.
Right, but he found it practical and safe for him to leave the vehicle initially because he was definitely in a place where it was safe for him to be. He removed himself from that place to approach her, so he made that choice consciously.
That I think is
meant
a self-standing violation. I just don't know that if it's related to this notion of like telling them who they are and stating the basis of the arrest just yet. So I have no problem with agreeing you that there is a violation of policy in his positioning in front of the vehicle. No doubt about that, 100%. And I actually think that that should be relevant to the self-defense case. No doubt about that. I just don't think that this specific provision of identifying oneself and the use of non-deadly force is relevant to that specific analysis. Again, I think it's relevant to the broader pattern and practice of the administration. But because I don't think that non-deadly force was applied, I don't think that that part is that relevant. And because I don't think that it was really practicable and safe at that moment to be like, hi, I'm Bob, and you're under arrest for this, this, and that, when she's like clearly trying to leave and she's like not stopping, I don't think that it's super probative to our analysis.
Well, it is in the fact that he was able to remove his phone, pointed at her, and, you know, begin taking video. So he felt it safe to use his own personal device to start recording her. And he found it safe and practical for him to leave the vehicle to do so. So her window was down as far as I could see. So at no point, at any point, he could have said, hi, I'm officer blah, 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 stop the vehicle. You're under arrest. And instead, he didn't.
For the purpose of this conversation, I will grant they should have identified themselves as ICE and said why they're stopping her, I guess. But do you think that she didn't know that they were ICE?
I can't read her mind, can I? You know?
But that's why she's there, right? Come on. She knows it's ICE.
I don't know why she's there. She could have just been driving around. I have no idea.
You don't know to a certainty, but what do you think is likely? You don't know to a certainty. What do you think is likely between you and me?
Why would I be arguing what is likely?
Because I find it interesting. Friend to friend.
Well, to my understanding...
I understand. I defend her too. I said it's a murder. Charge this motherfucker. But we can be honest and say she almost certainly knew it was, or I'll even just say she likely knew it was ICE. Now, did she know why they were stopping her? I assume she knew it's because of her activities. I don't know that she knew the specific statutory or regulatory basis of the stop down to the like reference. But also, fine, grant that that they didn't follow procedure on that. I don't know why that plays into the significantly. Maybe it's useful for atmospherics. Maybe it's minimally probative to the factual circumstances. But I don't know why it's a big point in favor of the self-defense argument. I think there are better other points. And I think that the violation of policy with respect to standing in front of the car, that is a way more of an important policy violation, in my opinion. And the use of force against the moving vehicle. I mean, those are violations of policy that I think are highly probative to objective reasonability.
Absolutely.
Yeah.
Yeah, I think.
But not this one. This one seems like minimally irrelevant, even assuming it happened.
Well, I think firing in a neighborhood also, because it was under. I was under the. Sorry, I was under the impression originally that she actually lived in that neighborhood because after the shooting happened, somebody approached and said, like, hey, I'm a doctor. That's my neighbor. So I was under the impression she actually lived there. I don't know if he was lying about that or if like he was just making that up to actually
Do you care about that?
try to treat her. Do I care about it?
Yeah.
Well, yeah, that would give her reason for being there.
And honking the horn for 3 minutes?
It's her neighborhood. Yeah, I don't know.
Why would she do that?
She's a horn honker. I have no idea.
That's just something I do in my
anyway.
neighborhood. Well, I mean, in New York, actually,
Yeah.
it happens with regularity, but not in the way she was doing it. I mean, I don't know why her living in the neighborhood assumes she did. So what? You think that's like a more justified reason for her to do the conduct or whatever? But then you have to kind of buy that.
Be there, yes.
You have to kind of buy this whole notion of like, oh, she didn't know it was ICE and she was just like totally clueless about everything. And she might have been under the impression that these were like bandits or something. And I just don't think that that's very likely.
Bandits.
Is that where you're going? Like she was reasonable?
No.
Like she might have not thought these were like law enforcement officers. I don't think that's reasonable to think.
No, I don't think it's reasonable. I'm just kind of memeing on that front.
You're forcing them to answer for everything, and I appreciate that. I think it's comprehensive, but it's not something I would necessarily put all your eggs into. And the authorization point to do the arrest, I mean, maybe there's an interesting point here. Like, it's possible that there's no obstruction statute that would apply to her conduct. I'm not sure. I kind of doubt it. And maybe I should be a little bit more uncertain when I make that proclamation, because I don't think it's like super relevant to the deadly force analysis. That's why I say it. And I think in general, these immigration officers have more arrest power than the typical lefty commie thinks that they do under the law. But as a matter of policy, everything you're saying is highly relevant to how Trump is operating the DHS and how obscene they're being. Like more broadly, I think what you're saying, these are like good questions about how ICE is being run. I just don't know that it's relevant to my specific obsession.
Your specific obsession. Okay.
Mm-hmm.
Yeah, I mean, I think that's all I have on the case, on this specific case. I mean, there's only so much we can talk about. But thank you.
Of course. Wait. What so are you, tell me, are you a Kamala voter? Are you a Trump hater? What's your background there? So people can know where you're coming from.
Oh, I'm a Kamala voter. I absolutely abhor Trump.
Mm-hmm.
He should be removed.
TOS.
I'll stop there. I'll stop there.
Jeez.
Yeah.
Are you a Mangione person? No. Say it ain't so. Uh-oh.
I mean, he did something, and that was kind of bad. You know, he did something.
Murdered a father.
That you're not supposed to do that. Yeah, you're not supposed to do that. So that was bad. He sent a message that was interesting, but you're not supposed to do that. Murder is bad.
It was
don't do
interesting.
murder. Yeah, he did something that was interesting, but don't do that.
Okay, who are your top 3 favorite left-wing streamers?
Oh, God.
Present company excluded.
God, please. I mean, I am a fan of Destiny.
Mm-hmm.
I do watch him. I am a fan. See, I don't watch that many. I only watch like you, Destiny, and part of Left Wing. But I watch some.
What about IRI,
too.
who just raided in from Twitch? Thank you, IRI.
Oh, IRI! Bro,
we have
I
a
love
fan
that
of
dude.
yours.
Just kidding. I love that dude.
Yeah, we love you, IRI.
I love IRI.
Yeah.
Yes,
we love that you support Israel, right? I'm fucking with you. You don't have to answer that. I'm just fucking around. Thank you, IRI,
but no, actually, big up to IRI. Yes, I love that guy. He's the best. He's pretty cool for a fly or whatever it is. I don't know.
Pretty white for a fly guy.
Yeah, that he's that.
All right. Well, thank you so much for your questions.
Oh God, I'm being cursed. Yeah, I'm being cursed in the comments. I better go.
I appreciate your contributions and good questions. So appreciate that and chat soon.
All right. Appreciate it. Bye.
Later. All right. Thank you, IRI, for the raid. We're doing some call-ins right now. We're doing some little call-ins at the moment. Great little call-ins. Thank you again for chilling we're going to continue the call-ins. We're talking about what Trump is doing. We're talking about ICE. We're talking about the shooting, and we're taking some call-ins from the community. The Doughboy, what up?
Hey, can you hear me okay?
Oh, I got you loud and clear.
All right, awesome. So this is, you can tell me whether or not you want to talk about this. It's kind of prompted by Josiah's super chat about ruthlessness.
Oh yeah, sure. Hit me.
Yeah, so I'm a moderate. I've voted for Kamala.
Hell yeah.
I very much against Trump. I hate that.
Yeah.
Republicans have become what they are. And maybe some people would consider some of the stuff I think should happen to the current administration kind of ruthless, but at the same time, some of the stuff I hear, like for instance, Josiah and Destiny, and I don't want to like say anything that you specifically have said because I can't recall everything.
It's okay. I won't grill you. Just tell me what the feeling you get from us and from me. You can include me at the feeling. I'm not going to grill you on specific comments.
Yeah. I feel like there's too much of an emphasis on Democrats should swing hard the other direction as soon as they get back into power.
You mean politically or in terms of consequences and accountability, or both? Or neither?
The consequences and accountability, I pretty much align with most of you guys on.
Okay.
I think a lot of the administration needs to be arrested and convicted for constitutional violations. But as far as trying, some of the things I hear people say about trying to make sure these things never happen again seem to be crossing the line over doing similar norm violations that Republicans have done.
Got it.
And as a moderate, I want to see a return to norms.
Yep. Can I ask some questions to just make sure the audience understands where we're coming from? Because I think I understand what you're saying. So you're not talking about like a swing politically into like Green New Deal or socialism, right? Because you couldn't say that like Destiny or Josiah are advocating for some sort of Marxist future, right? So you're not talking in terms of political, right?
I think it's a lot of liberals, and I agree with them on a lot of stuff.
Yeah.
I think there's just an attitude of wanting to use Trumpian tactics in order to punish Republicans
Got it.
for what they've done.
So just for the audience's sake, I understand it. What he's saying is, to the extent of the backlash, not politically from this perspective of ideological, but from the sort of norm or purported norm or alleged norm violations / tactics, you feel as though the focus is either tailored in a direction that you find troubling, that is to say that you're supporting tactics, or you feel we're supporting tactics that you think go too far, or in general are disproportionate to what is needed to get us back to a steady state that everyone can exist in and be at peace with, right?
Yeah, I see it more as like it's going to there seems to be almost like a revenge mindset of wanting to go fully in the opposite direction of Trump, using the same sort of tactics just to establish more solid Democrat rule, which
got it.
Would be better than current.
Yeah, no.
Trump rule probably, but
we can go about this different ways. You can take the reins if you want. That's one way. We could go through specific actions contemplated or suggested and see whether we have like a view there, or I could respond broadly to the characterization, whatever you want to do.
Let's start with you responding broadly.
Okay.
I guess like one thing that I would have a question, I kind of want people on the left to kind of see things a little bit more from a moderate perspective, because I think there's a lot of moderates out there, and we're kind of just being left in the dust.
Yeah. So here's my response broadly to the kind of feelings. First, on the terminology, I don't think it's useful to speak about it in terms of moderates, because I think that is invoking a kind of like political ideological sense, and I think that we're probably people could have the view of like quote unquote punishment or retribution from many different political angles. And so I object first to the framing of it. Not that you're meaning this, okay, because we've sussed out what you mean. I understand kind of what you're getting at, but I would try to label it more as this kind of retributive urge or something, or accountability urge that goes too far, or the norm violation proposals, okay, from a norm perspective, as opposed from like a moderate perspective. But I understand kind of what you're getting at. You're a moderate in the sense of norms and institutions, but I don't think people hear that when that's said. So that's my first point on terminology. My second point on the specific people you talk about, Destiny and Josiah, I think there are specific points of norm violations that they either propose or that I can think them proposing where I would agree with you, it goes too far. And I'll give you two examples, one from Destiny, one from Josiah. Let's start with Josiah. Josiah proposes that the executive, if there's a Democratic president, should do like non-acquiescence to the courts. He basically thinks that like the president, one way, legitimate way the president can keep the courts in line is to just ignore what they say. All right, he's said it. I don't know if he's backed away from that, but that was his position. At least he was flirting with that position heavily. That's an example of something that I would not be in favor of, and I think it goes too far. Destiny, this whole like Nuremberg thing, I think is a stupid idea in the way he's selling it. Not some of the impetus for it, but the notion of trying to charge everyone who supports Trump with insurrection without doing the task of like making out the elements. I think that is not justified. I think there needs to be a more tailored theory and a more sussing out of what is meant by that. And so the specific proposal I heard him on that WIC panel, I don't necessarily agree with. That said, my broad response is in general, I agree with their demeanor. I think that even if we disagree on some quote unquote norm violations, and I'm sure if we asked them, they would agree with some norms need to be respected. I largely agree with their focus on accountability and punishment, not for revenge's sake. And I don't think that either Destiny or Josiah would characterize it as for revenge's sake. I think that they would both characterize it as deterrence, specific deterrence, and accountability for purposes of general deterrence in the future. That until this is done, well, like that, we won't achieve the optimal deterrence. And I think also B, that some of these actors represent a danger in our minds to the Republic and to our people in their crime violations. And so to the extent, and I think that that's a great deal of what they're conceiving as the utility of some of these measures, I think that they're more right than wrong. And that attitude is one that I wish some of the Democratic leadership had more of and spoke more to. And I think that's where the Democratic base is. So even though I would agree with some points go way too far from both Josiah and Destiny, I think by and large their attitude is the correct one vis-a-vis punishment and accountability. But I'll let you take it.
Yeah, I think from the perspective of like accountability, I think that needs to happen. There's, in order to return to norms, you have to punish the violations of the norms. And I constantly argue with, for instance, my dad, he'll say like, I'm not a full-on Trump supporter, but I can't get him to disagree with a single thing Trump has done. But like, there will be, like I'll mention like impeachment, for instance, and I think like one of the clear just things that should be something that he could get impeached over was the whole Trump coin thing and not divesting his interest in that because of the clear conflict and interest.
Among others,
I think a lot of
I think that's a potential one. I haven't looked at that one as much. I would have to. Maybe there would be an abuse of power rationale there. But yeah, I mean, there's take your pick. Everyone has their own like favorite pet impeachable offense. For me, it's things like the Eric Adams saga. Another example is the violations on the Epstein law. Another example is the war in Venezuela, the war in Iran. Another example, like there's so fucking much, like, so many acts. Some of the crypto stuff, the deals that he's making with some of these Gulf states, the decision to pardon. I think that the pardon decisions on January 6th is also impeachable. I want to be clear about that. Just because he has the authority to do something doesn't mean it's not an impeachable offense. So, I mean, yeah, I think that there's so many. You take your pick, but I don't know how that gets us closer and more far away from the core of what you're trying to argue for, which is like some level of restraint.
Yeah, it's hard to describe because it's kind of a vibes thing. Just like the impression I get from the Democrats, and like you said, it's not really coming from necessarily anyone in actual Democratic power. So maybe that should be like something to.
I just mean specifically Schumer and Jeffries. I think that some people are talking to that, and I think it's base people. I think it's people like Chris Murphy, people like AOC, less some of the state actors who I think have their own sort of decision matrix. People like Mamdani, but yeah, no, I think that there are some collectors of Democratic actors who are talking about it, and to some extent, the reason why certain people aren't putting aside our leadership has to do with just like, well, we have no ability currently to do it, but that doesn't mean that we should not do it just because they're not talking about it right now. It might just be an intuition that other political situations have more staying power or they'll be more effective in the moment. And I don't think that you should read the silence of some Democrats as accepting a model of governance which decries or limits accountability. I hope that made sense. There's a little word salad, but I basically mean we shouldn't necessarily take silence on the issue of accountability to mean disapproval of it.
Okay. Yeah. Yeah. Like I said, it's a little hard to describe. I guess like one in particular thing might be like packing the courts, and maybe you can give your rationale
I support
for that.
I'll tell you why if you want.
Mm-hmm.
So I understand court packing. What I think is court packing is breaches of norms to affect the partisan balance of the Supreme Court. And the reason I say that is because the operative concern isn't with the amount of justices that sit on the Supreme Court. What people care about is the partisan split of those in the Supreme Court. All else equal, I think everyone would support having more Supreme Court justices just for caseload. What bothers people is the notion that we would affect the partisan balance of the court through some kind of like norm violation. This is my view on what the Merrick Garland non-hearing decision, the pocket veto by Mitch McConnell, one man in the Senate, was. I believe that was court packing. And I believe, therefore, that court packing by Democrats is justified in response to court packing by Republicans. And you might take issue with my definition or my view of court packing, but I want to get into that. And so I'll let you respond there, and I'll talk a bit about why I view those as, I view legislative court packing as better than what Mitch McConnell did. I view it as more norm restoring to do legislative court packing than what Mitch McConnell did. And we can talk about that too, but I want to give you a chance to respond.
Yeah, so I can understand the perspective from Democrats about Mitch McConnell kind of blocking that. I think that's a clear norm violation that should have happened, and it did stack the courts in favor of Republicans.
Well, let's imagine that Mitch McConnell,
the court would be like 50-50.
Okay, but let's imagine that. So I'll give you just the first question that I asked these people. Suppose that when Trump took office, they passed a law expanding the Supreme Court, and Trump immediately put in 2 justices. Would you be okay with Democrats passing a law to undo that action the next time they were able to?
Like they would pass a law and it would, like, they would remove those justices,
or add either do that or add. Let's just say add for now.
Yeah,
keep it simple.
Okay. Yeah, I'd be in favor of that. I think. Okay. The question for me is like, where does that stop? Then if Republicans get back in power, do they stack the court again, and do you just like keep running down this
So we'll get there for sure about like where does this end kind of thing. But you've granted that in response to legislative court packing, you would be okay with Democrats responding in kind. My argument is going to be a greater includes the lesser to you. If it's the case that you would be okay with legislative court packing from Democrats in response to legislative court packing by Republicans, I think that you should be okay with legislative court packing from Democrats in response to non-legislative court packing by Mitch McConnell in the following ways. At a bare minimum, legislative court packing requires bicameral passage and presentment to the president. And the non-legislative court packing done by Mitch McConnell was the decision of one man, Mitch McConnell. That's it. And if that's the case, there's no reason to prefer legislative court packing that we are proposing compared to non-legislative court packing done by one person, especially because it's within the powers of the respective actors, right? Mitch McConnell was well within his power as Senate Majority Leader at the time to not do a hearing and not to consider Merrick Garland. Absolutely well within his power to do that. Congress is well within its power to adjust the size of the Supreme Court by legislation. So the only distinction, right? Like on what score would legislative court packing be worse than non-legislative court packing?
Is that a direct question?
Yeah, it's a question for you.
Okay. I don't think that it's necessarily worse. My biggest concern always ends up being the where does that stop? Like, do we end up with
let's
100 Supreme Court justices?
So what I'm hearing from you is the following: you're not convinced it's worse to do legislative court packing compared to what I just said from Mitch McConnell, but you think the result might be worse in the long run, right?
Mm-hmm.
Well, let me just obviate that, right? Let me just address that. Isn't it preferable to have a Supreme Court that oscillates between when it's packed by Democrats or Republicans versus one that's only packed for the rest of our lives by Republicans? Which world is preferable?
I guess it oscillating.
Right. So in what sense would we prefer the world in which it's a permanent stacked court as opposed to an oscillating court? And so on every score, this is my greater includes the lesser argument. It's preferable to do the court packing in response to the non-legislative court packing. And because in the long term, it's preferable to have an oscillating majority according to the will of the people as opposed to one that was dishonorably and unfairly stacked by Republicans under Mitch McConnell. And what I would say is, as an olive branch, I would be okay with trying to work in a bipartisan fashion to fashion some kind of more neutral and moderate position through constitutional provision or bipartisan legislation to fix the issue in the long term. That would be my preference. However, failing anything like that from the other side, I would have no problem and no choice if I were in charge to approve this response based on the violation that occurred under Mitch McConnell, which is worse than legislative court packing. My view.
I guess, would there be alternatives to court packing, such as restrictions, like term limits or something like that?
Yeah,
that would be better.
That would be my first inclination, is to fashion some kind of more neutral, moderate, less openly partisan answer. That was Joe Biden's inclination as well. But failing that, I'm not going to be dissuaded into taking action which is premised on intransigence of the other side, corrective action that is justified, which results in a better world for everybody.
Okay. Yeah, I can see that as more
Do you agree
reasonable
with me?
than I was probably thinking about it before. I guess one other question I have, and I'm not entirely sure.
Do you agree with me?
No, I
what
do.
I said? Oh.
Yeah.
So you would support it as an alternative failing of bipartisan consensus on judicial reform, as I do.
I think so. I think my
Hell
impression
yeah.
of court packing was a lot more like you were coming at it from the perspective of like we just
Put
need
in
to get back at
1,000.
them
No,
type
no,
of
no.
deal.
So I would not support like packing 20 justices. I would say 2 or 3.
Okay.
No.
Yeah. I guess, and I'm not sure what rises to the level of violations of current Supreme Court justices as far as being partisan, because I know my understanding is they're supposed to restrict their at least perception of being partisan. Is there stuff that Congress can do to like enforce that kind of thing, or
It's there's a sneaky thing. There's a correct answer, an honorable answer, and there's a sneaky thing. Which do you want to hear first?
correct answer?
Okay. I think that a lot of what's complained about of these justices aren't, strictly speaking, impeachable. And Congress is absolutely within their authority to impeach and remove some of these justices. I have not yet seen a convincing case that would justify impeachment proceedings against any one of the justices. That's my view. This includes I'm not saying you shouldn't investigate. I'm not saying that you shouldn't like look into stuff, but the Alito thing doesn't do it for me. The Thomas stuff with the yacht and billionaire and flights and stuff, that doesn't do it for me. I'm not saying don't investigate. I'm fine with investigations, but nothing yet has risen to that level. Do you want the sneaky answer?
Sure.
Okay. Sneaky. So impeachment requires a majority in the House of Representatives and 2/3 in the Senate to convict. Okay. Congress, if it wants to, with bare majorities, assuming you get rid of the filibuster, and you can with a bare majority, they can just by legislation delete the seats of the sitting Supreme Court justices. And so I don't see what the constitutional issue is with a bare majority passing legislation with the approval of the president to just undo a Supreme Court seat. You know, they're still judges. They're still Article 3 judges. They just don't have a seat on the Supreme Court. And then creating new vacant seats and putting in your people. And I don't think you need to do impeachment for that. And I don't think that would be unconstitutional.
Does Congress get to pick which ones? Like which seats are removed? Okay.
Why not? But I don't know that,
I'm just asking.
I would just much rather not do that and just like add seats. Like I don't know why we need to do the sneaky thing, just to add seats. But I do think that's within the authority of Congress.
No, yeah. I think like your perspective gives me a little bit more. Seems a little less just like. I get worried that we're gonna swing too hard the other way. And like I said, this is more of like a vibes thing, and it affects like I'm gonna vote blue this year, but regardless, because I think there's so many violations that need to be dealt with. But it's hard as someone who traditionally was voting more red, to be like, I want to swing the country to swing in the opposite direction, because there are things I disagree with Democrats on policy about, and I wish we could go back to like actual policy discussions rather than being like arguing over how much power the president has to just implement different things and basically create laws on his own.
Well, I'm sorry, we're on the road to Mordor. We have to destroy the ring.
Yeah.
And there's no Shire to go back to, I'm afraid. And for the rest of your life, you're going to be dealing with this. This is our burden.
And as someone with kids, it's pretty hard to be like,
I know, but I have an important message for you. And that message is you need to think of this in the long term. You need to think about this in the grand strategy. Josiah is a little motherfucker, all right? He's a little motherfucker, but what is he right about? You don't have to worry. You do have to worry about Trump, obviously.
Yeah.
But you need to be thinking about the next game, not just Trump. Because Trump is old and Trump is dying. And Trump will be gone in your lifetime. God willing. But another demagogue can very much take from the ashes of the abyss that he's created in our country, from the power vacuum that is starting to be felt and that will soon be upon us, and will be more competent, more ruthless, and younger than Trump. And so you need to plan for that fight. Okay? This is why I'm so critical of Democratic leadership sometimes is I feel that they are myopic. They're focused on the next thing. And that doesn't mean we don't look at the here and now, like Yoda says. Follow what Yoda says. Focus now as well. But you do have to look at what's coming up next. And Josiah is absolutely correct that if Democrats are limited by this Supreme Court and the judiciary and towards making real change to the American people based on preposterous and bullshit rulings on the state of the law by a politically compromised Supreme Court, which I think it is, it will be ripe picking. And so we need to prepare ourselves for that reality, that we can't get to a good state with the Supreme Court we currently have. It will be too delayed. It will be too much bullshit and garbage that gets in the wheels, right? The Supreme Court is going to be enjoining way more stuff. Imagine if Biden tried half this shit. You don't even need to think like
I was just telling my dad.
So absurd to think the Supreme Court wouldn't be ordering Biden. No, you can't fire this Trump guy from like, I don't know, the mailroom. You can't fire this. Like it would be so different. And that's not to say that we should not obey the law as told to us by the Supreme Court. I'm not saying that I'm in favor of non-acquiescence, but the other branches are not powerless in the face of this structural problem. And so using their democratically granted authorities under the Constitution, we should address that problem, not through law breaking, not through violating the Constitution, but by working within it to fix this structural problem through the consent of our huge mandates that we ought to get. Now, that's what we need, though, a huge mandate. And we should not rest on our laurels that we'll achieve it. But we need it in order to get to where we need to go.
Okay. Yeah. I like, yes. I'm trying to think of exactly how to phrase my biggest one of my biggest concerns as someone who grew up super conservative is the rise of, like, I know probably at least 10 Christian nationalists.
Yeah.
Personally. And it's hard as someone who's like been close to these people to be like having such strong disagreements and have to be like, I don't want your kind of people ruling this country at all.
Yeah, like we need to. These people exist. I'm not saying unfortunately in the sense of like we should kill them or anything. I'm not advocating violence or anything like that. But we unfortunately need to share this abundant cornucopia, this wonderful land of ours, with people who have very different visions and ideas that are non-compatible with our basic principles. And I say this not because I think that we should like ostracize or discriminate against these people, just that it would be preferable if everyone agreed to those kind of basic precepts: respect for the Constitution, rule of law, equal protection, separation of powers, dignity, respect, all that stuff. We don't.
Yeah.
Someone needs to win and someone needs to lose, and we need to win. And I don't believe that there is someone like Counterpoints believes that there's like a consensus or some sort of synthesis that can be had that uses MAGA to usher in this, what he calls like a technocratic, national, conservative, whatever he says, whatever bullshit he's saying. There is no synthesis to be had. There is no unity to be had. This is not a dialectic. It is a war of ideas that we need to win.
Yeah. When I talk to people about this, the sense I get is they're so frustrated with, there seems to be like such a close to 50-50 split with people in the United States about what should happen. They're always complaining like, oh, well, Congress never gets anything done. And my perspective is that's almost as it should be. It's representing the people properly. If that's the actual, outcome of the elections, it's going to be hard to get things done. You still try to like cross the line and things like that.
Yeah, so we need to think
to get
big
things
and
done, but to like
Democrats need to not do these mistakes. And
Mhm.
they need to just continue to push and push and push and push. And I think that we'll be in a good spot. We have a lot of great candidates that could win for national office. And yeah, so I want us to not have these like super tight, crazy marginal elections that we've been seeing. And I want a bigger mandate. And in order to do that, we need to really be firing on all cylinders with our messaging.
Mhm. Yeah, I think it's my perspective anyway, as someone who like disagrees with Democrats on a lot of policy things, is like just that return to norms, trying to like, because policy can be done and undone through proper means, but to just see the amount of stuff that Republicans are just trying to push through unitary executive power, as they call it. And
they've like almost given up on legislation.
Yeah, it's weird to see that. I feel like the Republican Congress isn't really doing much of anything.
It's so inactive. They basically just take long breaks and talk shit and refuse to do stuff, and it's a mess. It's absolutely a circus.
Mm-hmm. Yeah, I won't take up any more of your time, but yeah, I appreciate the conversation, especially about, for instance, like the court packing. I think it gives me a better perspective of like where you're coming from.
Yeah, whenever you have a question about that, just really ask yourself whether or not it's preferable to have legislative court packing versus whatever Mitch McConnell did. People have this intuition that what Mitch McConnell did was somehow like not as bad as if he passed a law. And I just don't know where that intuition comes from. It would be better if Mitch McConnell passed a law, because at a bare minimum, it would require sign off from both houses of Congress and the president, and not just one guy. Like Mitch McConnell, one guy to the Supreme Court, and we all have to pretend that is like preferable to a law that is, when both sets of actors have the same power. And I just never understand why we accept that framing. But no, it's an interesting conversation, and I appreciate you bringing your questions.
Thanks for talking to me. Appreciate it.
Later, bro. Bye. All right. Unfortunately, I think this has to be the last one, because I'm almost healthy again. I just need to do some self-care, drink some tea. So good boy, it'll have to be in the future. We have another conversation. Mr. or Mrs. or Mix Vel Charlie, how you doing? Bell.
Doing well. How you doing?
Doing well, bro. How can I help you?
I had a disagreement about your this is going a little bit back, but your position on discrimination against trans people in employment. And this was your debate, conversation with Taftash, where you said that you would support an employer firing someone like a lizard man for being lizard man on the basis of their identity, but it seemed that you would support that they wouldn't support an employer's right to discriminate against trans people. And I wanted to pick your brain on it a little bit, because I had a gut reaction of disagreeing.
So my position is that not all forms of discrimination are bad, and that one such area of discrimination which is acceptable are on certain types of identities that are either incredibly rare and that manifests like a significant imposition on employers, and for which there is no like socially good reason to protect. So those are all the different things that come into my consideration, but the answer is no. I don't think that every identity ought be protected in the form of anti-discrimination frameworks. That doesn't mean that I think that you should like go after furry people in their private time type stuff, right? So it's it's kind of like, if there's no imposition on the employer, then maybe I'm more open to having some kind of like framework that protects people's private activities that don't bear on the employment for certain kinds of employers. But in general, I'm not of the position that discrimination is always bad. Hello?
In virtue of what should trans identity, what is it that makes a person's trans identity the kind of identity that should be protected?
Yeah. Want me to answer that, or do you have more? You might be breaking up, just heads up. But I heard enough that I could answer it if you want. Hello? Hello, Bell Charlie. Where's the caller? I'm gonna just start answering, Vel, and we'll get to hopefully hear your voice again. But there's a bunch of factors that go into my deciding that it's worth our time as a society to protect trans identity in employment. The first is meeting at least some bare threshold of percentage in society. Trans people are rare, yes, but they're not so rare as to be anomalous and extreme. They're quite uncommon, but I think there's a sufficient number of them such that it's not just asking too much of employers. B, there is pre-existing social conventions that not just are understood in the modern sense, but in a frankly ancient sense regarding gender that is well known to society. Vel, are you there?
Yeah, I just got reconnected. Sorry, and I picked you up on the stream saying something about the numbers of trans people being.
So I was going through my rationales, my reasons. I can restart if you want.
That'd be good for me. Thank you.
Okay. So the first thing I said was there's like a bare threshold, and again, this is so annoying from Violent Smoker. Just because I can't give the exact numerosity and a number of people doesn't mean that I don't think that there ought to be some threshold in terms of numbers. That just like I can't define perfectly, a concept such like the exact molecule that a pile becomes a mountain or something, or a lake becomes an ocean. Doesn't mean that it's not a concept that we can separate. And so, again, without giving a precise definition, at least some amount, minimum threshold of size. Okay, so sure. I'm not going to buy into this Sorty's paradox bullshit you can use for anything. Okay, that's number one, is a threshold. There's more trans people, and significantly more, and they're more, it's more understood, and that's number one. Number two, it's mapping on to ancient and well understood social conventions regarding gender. And I actually think that the definition of gender regarding that is intuitive to people, and that existed before people finding out about genetics, and had to do with these categories and from the gender perspective. And so it's not asking of society to fundamentally recreate all the aspects of their social conventions. There are some differences, no doubt, but I think that they're mapping. It's like we're not adding a new race to the expansion pack, right? We're not adding Protoss. We're adding, a category of people to map onto pre-existing social conventions and norms. That's another thing. 3 is the significant negative effects that persist to this group in the absence of such protections. And 4 is it's kind of similar to 2, what I think are the minimal costs of compliance with such standards. There's probably more, that goes into that as well.
Mhm.
But that's the kind of sense of how I'm thinking about it, is the size of the group, the costs for failing to do this, the imposition on the employer, and whether or not it represents some sort of massive shift in how we approach business relations, etc.
I'm not sure that that 3 it may happen to hold in the specific case of Lizard Man, but I don't know if it is gonna always hold. But it could be part of the circumstances. I'm more interested in number 1, because it seems to me that it would permit discrimination against trans people if trans people were rare enough. And I didn't know if that was a bullet that you were actually going to bite.
Yeah, I'm not sure that these are all necessary conditions, in the sense of, but for this, then that. I think that it's part of the overall factor analysis, but I'm not at this point. I haven't formalized it. And I'm not willing to bite the bullet that it's a necessary condition. Just merely that it's part of my analysis that feeds into it. It's something that I consider that's relevant, but I'm not at this point, without thinking about it more, committed to it being necessary to protect. Does that make sense?
That makes sense.
Okay.
I don't mean to like into a debate on something that maybe yours staked out position on here.
No. These are the kinds of things I'm thinking about, but I'm not sure if the size component is required for me to think that such. So I can imagine an identity that is so low cost to respect and so unimposing, and there's just no good reason for anyone to ever discriminate in that respect against it, that I would maybe consider protecting that, even though it's held only by one person. But these are the kinds of things that I think too when I think about like what is worth protecting, not that it's a necessary condition.
The kind of thing where you're talking about sort of being a lower imposition, essentially. Just what I'm picking up you saying is that Lizard Man is really weird, and being trans is not so weird, and so I'm not sure that alone, or sorry, not alone, but that I'm comfortable with that at all could factor in.
I don't think I used the word weird or implied weird, unless you mean
the imposition on a person for to not discriminate. They would have to tolerate more. A person who's
so I don't think
different. I'm sorry.
Maybe the weirdness. Okay,
yeah.
Yeah, sorry, I think there's a delay. I'm not trying to interrupt you. I think the weirdness aspect, if by weird we mean known, right? The conventions that are known to most people, then maybe weird it fits there. And there I would just like ask you, man to man, or I don't know if you're trans, man to man, like, isn't it obvious that the norms related to gender are more well known to human society than norms related to lizard people?
That is true, yes.
Okay, that's what I mean.
And that means that it's a significant imposition to respect someone's niche identity.
Right. So the protection of niche identities, to the extent, like, okay, I need to remember my lizard prefix, and you need to remember I'm cold-blooded, and so keep that in mind when you're doing the temperature. You know, it needs to be 50 degrees because I'm like cold-blooded or I don't know what the fucking the shit is. I don't know things about lizard, but like you start to add up stuff that is the kind of impositions that a lizard person would need with respect to their identity, and even the notion of like, I don't want you to say my name when we're at a team meeting. I want you to like put out your tongue and say whenever you refer to me as, okay? So that's not the kind of imposition that like respect for transgender identities demands. It's stuff that is like in the wheelhouse of ordinary people. And in fact, it's so within the wheelhouse of ordinary people that sometimes even like transphobes can't help but adhere to those standards. Like when it comes to someone like Blair White, like the standards are almost like instinctual in that respect, and they have to make an effort to fail to comply with them.
So it's your view that really people are making maybe a bigger deal about accommodating trans people, such that if they were making that same deal about a more niche identity like lizard man, an identity that doesn't map onto social conventions that people are already well practiced with, maybe then they'd have more of a case for their employment discrimination. Or
yeah, the more esoteric, the less common, the higher the cost of compliance, I think the less reasonable, and the less need society needs to like institute specific laws of general applicability to address it, right? Like maybe there's a specific instance of a discriminated lizard person, and the way we resolve that is just by having an accommodating employer deal with it privately, right? We're talking about legislation and frameworks of general applicability. And I don't know that like these off cases are worthy of such protection. Now, maybe if there's a way to categorize them as like off premise conduct that doesn't affect the job by any reasonable standard, maybe that's something I would be okay with. But to the extent of esoteric identities that truly demand compliance costs from employers or tolerance that not engendered by adherence to normal conventions regarding gender, I think that maybe it's not the right domain for legislation or employee frameworks. I'm sorry. I think you're cutting out and stuff, or like I can't hear you. I don't know if you're like in bad Wi-Fi conditions.
Gotcha.
You didn't.
So
yeah, go for it. Go for it.
So yeah, that'll make sense, and I mean that connects with, to me, another reason, almost unrelated to protecting trans people, that you might still have these protections that encompass trans people, which is, I think, this there's a sex discrimination concern if you're allowing certain employees to present in a certain way, to follow a certain dress code, but then if they're not part of a if they're part of a different sex, then they can't follow that dress code. That's sort of similar, in my view, to this idea of identity mapping onto well-established distinctions that we make between genders, and so it not being a significant imposition to allow someone to behave that way.
Wait? So is that you agreeing, or is that you saying that there's a set of employee restrictions categorized as sex discrimination that we're allowing trans people to like violate? It's going to be tough if you don't have access to like good internet to respond in a timely fashion.
That was me agreeing with you, but yeah, my internet is got it right now. So
yeah, so like no, but basically my view is that in the case of trans people or people with no particular gender that they identify with or anything like that, it's either asking for the application of like well-known standards to individuals that are like with us in like hundreds of years, and that have been developed over the course of hundreds of years, or it's asking for such norms to not be applied in one instance. And I don't think that that's a huge imposition. And I think that that there's enough of them that we should consider it and that we should make it something that we protect. And it's not asking that we use Z, Zim, Zer, or like some other crazy set of things. That's not what I'm saying. That like, but for using Z, Zim, and Zer, or but for using, I don't know, some sort of like furry pronoun or something, that you would make out some violation. I think that in the case of trans people and non-binary people, we have the tools for that. We have the tools for a trans woman, her, she. There are women who present very masculine, who are biological women, and people will sometimes make mistakes, be like, "Oh, ma'am, I mean, sir," on the phone. Like, these kinds of stuff happens, and I think that sometimes the frameworks will lead to overcorrection potentially. But as I sit here, I think that there is a distinction, and not all identities need the protection of the law. Trans identity, though, is one that I think deserves the protection of the law.
If that wouldn't extend all of the types of protections that certain non-binary people might
request,
or,
right?
All neo-pronouns, but if they're requesting they,
since
people use they, really, that's not the kind
right.
of
Yeah. So
that you're talking
it shouldn't be heard that just because I think that trans people should get the protection of anti-discrimination frameworks, that I agree with them on how they should, all those different disputes should be adjudicated. Like, sometimes I think the employer should win. And I don't think that all claimed instances of transphobia or discrimination should be viable claims. I just am saying that at a basic, I think that some discrimination frameworks should apply as to protect trans people, but not every request. Just in the case, by the way, of racial discrimination, not every claim of racial discrimination should be heard and adjudicated as meritorious. This is true of all protected classes. I think that it's a different question as to the extent of the protection, as opposed to whether or not in any respect they should be protected.
Gotcha. Sounds good.
Good questions, brother. I might reach out to Taff and have a follow-up, because I have some questions, but I appreciate you referencing that.
I mean, about like which group was negatively, like whether it was progressives were reaching, or whether the reaction that conservatives had was like mostly motivated by, I think, their just opposition to trans people violating the binary that is so important to them. But be interested to see you guys.
Yeah, I want to suss that out more, because I think she feels that a lot of lefties have failed trans people, and that a lot of the discrimination is a result of like overreach or something. And I'm not convinced by that, but certainly I'll reach out to her and we'll see if we can have a follow up. Okay.
You too.
All right. Later, brother.
Later.
Hey guys, I see you in the hall. I'm losing steam. I'm getting better, but I'm not 100% yet. And tomorrow I need to like rearrange my room in case this Drew Pavlu motherfucker comes through, because he's gonna have to come in here. So I need to like think about how to set up the room if you guys want Drew and the special guest, which is a wild special guest. I don't even know if it's gonna happen. Like I said, 70%, but the guest choice is just interesting to say the least. And the less said about it at this point, the better. And yeah, so stay tuned on that. It would mean the world to me if you liked my recent video, and keep it playing on a tab. Tomorrow, 9:00 sharp, and I'll release the full conversation with Crystal and Kyle. I think it's a good one. Reminder, I was sick. So if I have some like lingering, like my voice a little whatever, just it's a good conversation. Just watch it. All right. I think I sound good, but decent. But just know that like I struggled to get prepared because I was feeling pretty bad. But I wanted to do it, and I think it was a wonderful conversation. I think you'll really enjoy it. There's a clip of it already available on Secular Talk, but you can watch. I would love it if you watch the full one on the channel, and give it a like and let it play out for the algo. So love you guys very much. Hopefully tomorrow at 6:30 we'll be live with Drew Pavlu and guest. No promises there, which will mean that we'll either cancel Lib and Learn or I will not be on it if the conversation goes through. So just a heads up on that. And love you all very much. Stay cool. And Gene and Good Boy, we can have a conversation in the near future. Next time I do call-ins, probably not tomorrow, but like the next day. But yeah, stay cool.